57 2 p.m.
WPC number 7469 of 2017.
Yeah, 2 p.m. for us. It is listed that item number 57 will be taken up at 2 p.m. Top of the list. This is that prawn gheri matter. Usually it is taken up
2
at
p.m.
2 p.m.
Weekly list fresh admission item number 1.
Your Lordship, sir, in this case, I am appearing for the opposite part number 1 and 2. Instruction is the purpose for which this PIL has been filed. They already infructuous, my lord, because the railway overbridge already completed since 9/4/2021 and it is used for the general public.
I am for the petitioner, your Lordships, and the matter has been rendered infructuous.
Counsel, the petitioner states that the petition has been rendered infructuous. It is disposed of.
Oh, Union of India, my lord.
He is not for Union of India, sir. He is for the
My
petitioner.
lord,
He is saying it has become infructuous, which is what I have dictated
my
just
lord,
now.
my lord.
If I've made any mistake, sorry.
No. Sorry,
all
sorry.
right.
I could not.
I don't know. What is that single judge case, sir? Connected case. Is that also infructuous?
No, my lord. I am for the petitioner, man.
All right. List before the roster bench
Oblige.
on 10th April.
Weekly list fresh admission item number 2.
May it please your Lordship, appearing on behalf of Mr. P.K. Behra. My lord, no instructions with
No
liberty.
instruction dismissed. All right.
My lord, with liberty to.
No. Yes.
Item number 3.
Obliged, my lord.
Weekly list item number 3.
None appears dismissed.
Item number 4.
My lord, petitioner can be permitted to withdraw the writ application to file statutory appeal. Original assessment order annexed to run can be written.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file an appeal against the impugned assessment order in accordance with law. Which appeal is filed not later than 10th April. Sorry. 1st March 2023, accompanied by an application for condition of delay, explaining the delay on account of the pendency of the petition. Then it will be considered in accordance with law by the appellate authority. The court clarifies it has not expressed anything in the matter. The originals be returned, subject to being substituted, attested photocopies thereof.
Item number 5.
My item number 5 also similar as my lord. In this case, it is under the 12 for assessment order expiry due to non-service of notice. Major portion of C declarations are in possession of the petitioner. My lord, pass similar order. 10% regarding pre-deposit. If 10% pre-deposit is declaration from the possession, it will exclude the.
Same order.
Original assessment order may be written.
All right. Originals be returned, subject to being substituted.
Item number 6.
I appear in this petition, your Lordship, there is a challenge to section constitutional validity of section 16, subsection 2, clause C of the Central Goods and Services Tax Act, as well as your Lordship, Odisha Goods and Services Tax Act. That this particular section provides that if
So we will not grant interim order.
yes, your Lordship.
So then the assessment should go on, sir.
Yes, your Lordship.
It's a notice returnable. 3rd July. 3rd July. Replies be filed within 8 weeks, rejoined up the next date. It is made clear there is no interim order. That in application for interim application 170712. The court finds no reason to grant any interim order at this stage. This application is dismissed.
Item number 7.
But one request, your Lordship, that the order which will be passed subject to the proceeding of assessment, let that be kept in abeyance. They may proceed with the.
Sorry, sir, they're not passing it on.
One more request, your Lordship. This particular issue that section 16(2)(c) challenge, your Lordship. This is, your Lordship. This was several. It is pending all across the country, and one transfer petition was filed before
So all this, you take a chance, you have consciously filed this petition. If
Yes,
you
sir.
do not wish to press it, we'll say not pressed.
No,
Ah,
that is not.
All right.
Great.
Item number 7.
May it please your lordships. Here, my lords, the question which arises for your lordship's kind consideration is, can the revenue retain my seized articles, that is stock in trade, without disposing of my application on the Annexure 12? And when there is no demand, area demand against me. My lords, the facts are, the petitioner before lordship purchases gold bar and gold biscuits from the by taking advances from the customers, and it is duly reflected in the stock register.
We'll ask them to dispose of your application in a time bound manner.
Now, what I say, my lords, that the
Only
Annexure 12,
That's what, Annexure 12 you've submitted when?
submitted in September, my lords.
All right. So we'll ask them to dispose it of now, sir,
My lords,
in a time bound manner.
no, my lords, what may I say something, my lords?
Yes,
With your lordship kind permission?
Yes, please.
If the investigation officer sees that the retention or the seized articles are duly explained, he may release the articles. That is what my small prayer is.
No, let him deal with your application. Then if he does not do, you will always come back, sir.
Already, my lords, 120 days has been passed.
Right.
Okay, as per the statute, my lords. And further, my lords, I am going on giving application, that is Annexure 12, my lords. Lordship, Annexure 12 at page 62 to 605.
Right. 14 September.
By
14 September.
14 September. My lords, then your lordship may kindly see.
Do you have an acknowledgement that they have received it?
Yes, yes.
Where is that?
Last page, my lords.
105.
105. 105.
All right.
Yes.
All right.
What I pray, my lords, lordship may direct him, because my business has come to a standstill.
No, we'll do it.
May
in
I
time
pray,
bound
my
manner.
lords, most humbly I pray, let him dispose of by 10th of February,
All right.
with giving an opportunity of hearing.
All right.
That is what I pray, my
All right.
lords.
At this stage, the grievance voiced by learned senior counsel to the petitioner is that the applications made in terms of the proviso to section 132 capital B bracket 1 bracket Roman small 1 by the petitioner of the Income Tax Act 1961 by the petitioner to the income tax officer bracket investigation bracket Cuttack, followed by reminders on 14 September 2022, followed by reminders on 11th October 2022, 7th November 2022, and 29th November 2022 have not yet been disposed of. Full stop. He accordingly prays for directions for time-bound disposal of the said applications. Paragraph. Having heard learned counsel parties, the court directs that the aforementioned applications of the petitioner shall be disposed of by the ITO bracket investigation, after hearing the petitioner on a date to be informed to the petitioner at least 1 week in advance, by a reasoned order, not later than 10th February 2023, and be communicated to the petitioner within a week thereafter. The court clarifies that it has not expressed any view in the matter. It is further clarified that depending on the order passed by the ITO investigation, it will be open to the petitioner to seek appropriate remedies in accordance with law. The petition is disposed.
Same also in item number 9.
9. All right. Same order in 9. All right. Sir.
My lords, I just now the petitions have been disposed of, and I have I agree. I bow down to your lordship's order. I just want to bring to your lordship's kind attention of a judgment of the Supreme Court, where it was retained beyond 120 days, and the Supreme Court imposed imposed heavy cost. I said, why you have retained?
So you give a copy to Mr. Chimanka?
Yes, I am giving it. Yes, Chimanka is my lord Kumbhakarna. He is sleeping since
No.
September. He's not waking up.
He never, see, he never fails to appear in any of your matters.
Yes, yes.
Then you can't say he's
Friday.
But you have,
Release from inside car.
he appears to inside the car also. Sometimes while taking breakfast, he will appear.
That's a reflection of the sincerity. Milord.
Yes. I bow down. So, Lordship, I have given that judgment. Lordship may kindly keep it on record, my lords.
All right,
Yes.
all right, all right.
Much obliged.
Item number 8.
May I please, Milord?
Yes,
The petitioner, Milord, was initially registered on under this central authorities, Milords. And unfortunately, due to some reasons, he could not file his returns and his registration was cancelled with effect from 14/10/2019. That was for the financial year 18/19. Milords. Subsequently, Milord, he was given another GSTIN, Milords, for the financial year 19/20, Milords, with effective from 21st of December 2019, Milords. Then, Milord, a proceeding under 74 was initiated by the state authorities on the ground that certain taxes were pending and they have to pay, Milord. If the Lordship would kindly turn, Milord, to page 30, Milord, that's the demand, Milord, under DRC 07, Milord.
yes.
Your Lordship would appreciate that the tax amount is 39 lakhs amount, interest is 13 lakhs amount, penalty is equal times, total tax demand is 92 lakhs 90. Thereafter, my lord, immediately, I paid, my lord, as per my own volition, my lords, on an amount of rupees 20 lakhs. Your lordship would get it at page 37, my lords. I paid an amount of tax of rupees 20 lakhs 68,196 and interest of 5 lakhs 59,154, total 26 lakhs amount. I've calculated the entire figures from the previous page, my lord. So this figure comes, my lord. Then I filed, my lord, application for rectification, saying that this amount has to be deducted, at least the tax portion has to be deducted, so that if I file an appeal, my lord, I have to file a pre-deposit on a reduced amount. So this particular my matter was kept pending. In the meantime, the CGST authorities also started initiating a proceeding for the same year, and the CGST's order is at page 41. My lords. They took up, your lordship,
Yes.
they took up, my lords, for the same financial year 18/19. And they say it's because of closure. And they, in the second paragraph, if the lordship would see, they say that 3 lines from the bottom of that paragraph, hence no short or non-payment directed as in VAMIS data shared for the assessed period 18/19 in respect of the petitioner, my lords. So for this 18/19, demand is raised by the state authorities. According to my own volition, I pay some amount of tax. The central authorities say that there's no outstanding tax as per the VAMIS, my lord, and VAMIS was also relied upon by the state authorities. But unfortunately, my lord, my rectification application, even though the learned authority, my lord, recognizes, take cognizance of the fact that these amounts are being paid, my lord, at page 46, at the bottom of that paragraph, my lord, which is in bold letters. So she says that hence amount of rupees 10 lakh 66 1.
That is after issuance of
Right.
assessment.
I have no grievance, my lord. My only humble prayer, my lord, is since the total amount, my lord, I don't make a grievance regarding computation, my lords. My only, my lord, prayer before your lordship, my lord, out of the tax amount of 39 lakhs amount, my lord, I have already paid 20 lakhs amount.
So wanted to pay 10 lakh 66,000 more.
My lords, that is due, my lord, according to the lady, my lords, officer, my lords. And then she says that you have to pay another 6 lakhs amount towards interest. And no penalty has been paid, my lord. So my humble contention, my lord, once you take cognizance of the fact that I have paid this amount, my lords, even if I file an appeal, my lord, I'd be paying 10% of this amount, my lord, not the entire demand, my lords. So my limited prayer before your lordship, my lord, your lordship may relegate me back to the appellate authorities, my lords. I go to the appellate authority. Limited prayer, my lord, is this amount of tax paid towards in tax, my lord, that has to be considered, my lords.
No, but will you pay this other 10 lakhs and?
No, this 10 lakhs amount, my lord, that means the language of the statute, my lord, is I pay the entire amount of admitted tax. Then I paid 10% of the remaining amount of taxes disputed. That is the language of 107. If your lordship may kindly take up 107, my lord, for a moment, my lords.
No. So according to you, the disputed amount is this 10 lakhs
Disputed amount is 10 lakhs according to them.
plus 6.83.
No, interest is not there. I have to pay 10% on the tax amount. So that is my limited prayer, and there's no dispute regarding the fact that there's a payment.
Your Lordship, the only issue is that whether that voluntary payment can be decided after issuance of assessment order. That is the. But the submission of my learned senior is right, Your Lordship, since it has been admitted and it has been paid. Your Lordship can direct that
All right.
remaining
All right.
and subject to verification, Your Lordship.
All right. It appears that against the order dated 19th February 2021 passed by the CT and GST Officer Bhubaneswar under section 74 of the CGST/SGST Act 2017. The petitioner has pending the disposal of his rectification application voluntarily paid a sum of rupees
26 lakhs 27,350, including interest of 5 lakhs 59,154.
Where do you get that figure?
That was 37. I've calculated that figure, Lords.
Ah.
The entire column I've calculated, Lords.
Yeah.
The tax amount paid is 20 lakhs 68,196, and the interest is 5 lakhs 59,154. Total amount is 26,27,350, and that is also acknowledged, my Lord, by the authorities.
There in this page.
But total, I have calculated it. And your Lordship would get it at page 46. Page 46, 1, 2, 3, 4, 5 lines from the bottom of that paragraph. Further, the tax paid. Lordship got it, Lords? That highlighted portion, 4
Right.
lines from the bottom.
Yeah.
Further, the
The voluntarily paid rupees 29. 29. No.
my Lord, 20 lakhs 68,196. That is the tax paid, my Lords.
All right. Paid rupees 20,68,196 apart from
Interest of 5 lakhs 59,154.
interest of rupees 5 lakh 59,194.
154 minutes.
154. Full stop. Paragraph. The prayer for rectification has been rejected by the CT and GST officer, Bhubaneswar 1 Circle, by an order dated 17th December 2022, requiring the petitioner to pay a further sum of rupees 10,66,619 towards tax and rupees 683,805 towards interest. Paragraph. Counsel for the Mr. Karan, learned counsel for the petitioner, states that the petitioner will seek leave to withdraw the present petition with liberty to file a statutory appeal against the impugned order dated 19/2/2021, subject to the court clarifying that the pre-deposit amount at the time of filing the first appeal will be 10% of the balance tax demanded after accounting for the above payment already made by the petitioner towards tax. Paragraph. Accordingly, while permitting the petitioner to withdraw the present appeal with liberty to file a statutory appeal in accordance with law, it is clarified that the pre-deposit amount will be calculated at 10% on the balance tax demand after deducting the tax amount paid by the petitioner as aforesaid.
And the amount already paid may be treated as admitted tax.
That is admitted tax.
This is
10% of the balance amount.
if such appeal is filed not later than 1st March 2022, accompanied by an application for coordination of delay explaining the delay on account of the pendency of the present petition, will be considered in accordance with law by the appellate authority. The court clarifies it is not explicitly in the matter. The originals be returned, subject to being substituted with attested photocopies.
Greatly obliged.
My lord, I am appearing for opposite party number 3.
All right.
Item number 10.
Item number 10, we have no instruction, my lord.
No instructions dismissed.
Item number 11.
My lord, item number 11 after lunch, I prefer.
After launch.
Already similar orders have been passed and the annexure 6 has been quashed by a previous bench of this honorable. I'll pass on the order after lunch.
All right. After,
And we are,
all
my
right.
lord.
Item number 12.
My lord, item 12 to 16, can I request my lord to take it up tomorrow, my lord? Mr. Pal will argue the matter and he's not well, my lord. He has requested me to request your lordship to take up the matter tomorrow.
Against the demand.
This is
notice.
short drawn MGQ. I think there's a provision of a commissioner.
Yes, that is usually this order is passed. The demand notice is to be challenged before the commissioner. And if any interim order is there, that will continue.
Continue till he disposes of. Right. If there's an interim order, let's just see.
Demand notice, I think at page 18.
My lord, may I then keep it after lunch then, my lord?
All right, after lunch.
Are you obliged?
Item 12 to 16. Item number 17.
None appears dismissed.
Item number 18.
Lordship, I have filed on restoration application. It was disposed of in terms of the severity, but thereafter we are examining that it is more than the limit. So Lordship kindly restore this case and
No, but notice has to go, na, this first.
no, your Lordship has given liberty that if it is beyond that, you have
That's
to.
right. But notice will have to go.
Your Lordship.
Notice returnable. 17th April.
Much obliged.
Item number 19.
Item number 19, your lordship had, on the last occasion, had permitted me to file an amendment application for framing the proper question of law.
Yeah, those amendments is allowed that IA29 of 2023. Now, what's the question?
Question is at page 4 of the amendment application. 1, 3 and 4 will suffice. my lord.
All right. Admit main matter. Say admit the following questions are framed. Take from 1, 3 and 4 in the schedule. Say list on. Copies be served on list on 7th August.
And in the connecting matters, my lord, question number second matters.
Sorry?
Question in the second sub item,
Yes.
question number 1. In all 3 matters, question number 1.
Okay. In the other 3, you say admit and question number 1. At page, which page? you find?
Page 13.
In the amendment.
No, there is no amendment.
Main question.
Page 11.
Page 11. Question 1, page 11. August 14th. Right.
Item number 20.
Obliged.
May I please? The question of law has been framed at page 10.
What is this amendment application you filed?
Amendment application that they are not taking the grounds, that is 40, 31, 40, 41, 42 has not been complied. By passing the order, similar matter, I am case of automobiles case.
So the amendment is allowed straight for. Then in the main petition, you say admit the following question is framed for consideration. Whether the exercise of power under section 43 of the OVAT Act without there being a self-assessment in terms of section 39, 40, 42 and 44 is justified, question mark. Paragraph. The above question is no longer a centigraph and stands covered by the decision dated 1st December 2021 of this court. In STRV 64 of 2016, bracket Keshav Automobiles State of Orissa, which was affirmed by the order dated 13 July 2022 Supreme Court of India in SLP Civil 9912 of 2022, bracket Deputy Commissioner of Sales Tax versus Zarati Steel and Power Limited, bracket. That view of the matter. Their question framed is answered in the negative, that is in favor of the petitioner as seen against the department. the impugned order of the sales tax appellate tribunal and the corresponding orders of the first appellate authority and the STO assessing authority are hereby set aside. The revision petition is disposed.
Item 21.
None appears dismissed.
Item number 22.
Same order.
Item number 23.
Well, it's item 23 to 26. I seek 1 week time to remove the defects.
All right, defects be removed within a week. List on. February 13th.
Up to 26. For orders, item number 27.
May it please your lordship. Assailing the inaction of the opposite party number 3 on the representation of the petitioner for regarding encroachment of a public road, my lord. My representation annexure 10, my lord. Earlier also there was an order for eviction of the opposite party number 4. There was an eviction. The opposite party number 4 has re-encroached upon the said land. We again represented before the Tahsildar and no action has been taken on it.
All right, the petitioner's representation shall be examined by the Tahsildar both. And after issuing notice to the petitioner as well as opposite party number 4 and giving them a hearing, the reasoned order shall be passed thereon not later than 10th April 2023 and be communicated to the parties within a week thereafter. Court clarifies it is not explicitly in the matter. The petition is disposed.
Obliged.
Item number 28.
Item 28, your lordship, 1 week time may be granted to remove the defects, your lordship.
All right, list on 15th February. Defects be removed.
Item number 29.
Wait, please, my lord. My lord, my case is that, my lord, my grievance petition with regard to use of, my lord, the forest land for cremation has been made, my lord. I made a grievance petition annexure 3 series before the forest officer, my lord.
All right, petitioner's representation, bracket annexure 3 series shall be examined
by the DFO, my lords, the
Divisional Forest Officer.
Divisional Forest.
Jajpur, bracket opposite party number 4 and after notice to the petitioner as well as petitioners as well as opposite parties. 9 to 17 and after giving them a hearing, the reasoned order should be passed thereon not later than 17th April 2023 and be communicated to the parties within a week thereafter. The court clarifies that it is not expressed anywhere in the matter.
Item number 30. Item number 30.
Sorry, my lord. My public road are encroached by the OP number. So my representation addressed to the Tahsildar, the authorized under the OPL Act. My lord, the page 12 mile annexure 2, the record of right is in annexure 1. So all the plots are road, public road. So annexure 2, page 12 is the application to the, my lord, the some Gram Sabha members for inquiry and removal of encroachment after, my lord, the measurement.
As there's no postal receipt or any acknowledgement in the
my lord, hand delivery officially the so lordship may
Permit you to make fresh to make a
representation.
fresh representation to the authorities. And after following up with such representation to seek appropriate remedies in accordance with law, the petition is disposed of.
Well, obliged, my lord.
Item 31.
May I please, my lord? My lord, kindly have a glance to the synopsis I have filed, my lord. Here the petitioners are the scheduled tribals, my lord, before your lordships, against the open dumping act under the Koraput municipality. My lord, as per the Swachh Odisha, Sustha Odisha campaign, the government of Odisha has to construct micro composting centers, my lord. But my lord, still date, open dumping act is going on, and for searching of food, one bear came and attacked one of the villager, my lord. who was seriously injured and admitted for 10 days, my lord. So, my lord, I humbly pray to take notice against the Koraput municipality. In their website, my lord, also under an annexure 5 running page 32, helplessly the Koraput municipality has disclosed that the work has been carried out by Koraput municipality. It is done on daily basis and is supervised by the sanitary inspector. The dumping, however, is done not far away from the slum area, and thus there is a foul smell and polythene scatters all over the area.
You can go to the NGT, sir, for this.
My lord, NGT, my lord, it is the urban development department has to do this, my lord, micro composting.
Why not? Why can't you go to the NGT?
My lord, NGT, my lord, it is a fit case, my lord, to be decided here, my lord.
No. All cases are fit to be decided here.
My lord,
you can go to the NGT.
My lord, I humbly pray, my lord, I will take notice on Koraput municipality, my lord. Who cannot afford, my lord.
What you can't afford?
Humbly, my lord.
No court fee also.
My lord.
An online hearing. So you can straight away.
My lord,
yeah,
I will take notice.
You can appear from your house also.
My lord, my lord, I'm praying.
No,
my lord, I will take
notice. Permitting the petitioner to approach the National Green Tribunal in accordance with law. The petition is disposed of. All right.
Wiki list for orders item 32.
32, my lord, shall just stay with weeks time for removal of the defects.
Or list on 15th February, defects be removed in the meanwhile.
Item number 33.
If you were levy of interest on entities, your lordship has picked the matter in second week February. In the meantime, defect only government is, I will remove.
List on 2nd February.
2nd February.
Defects be removed in the meanwhile.
Item 34.
Oblige. Interim order.
Item number 34.
None appears dismissed.
Item 35.
My lord, 1 week time may be given for removal of defects.
List on 22nd February. Defects be removed in the meanwhile.
Oblige.
Item number 36.
My lord, the petition is before NCLT now.
All right. The petition is stated to be before the NCLT. Accordingly, the petition is disposed of.
Item 37.
Defect has been rectified. Copy has been solved. This is only appeal order against that 20% order.
10% paid.
10%
Same order.
Item 38.
38, my lords, 1 week time for the removal of defects.
This is 18 matters, sir.
My lords.
Oh, why should we give you more time? We don't give you more time for this. Defects have not been cured for more than 4 years now. The court does not propose to grant any further indulgence in the matter. The petition is dismissed for non-prosecution.
Item number 39.
39, not press with labor to approach civil court.
No. Disposed of is not pressed. That's it.
Item number 40.
None appears dismissed.
Item 41. Item number 41.
Right. Step for limitation not taken.
Impune order that
Step for limitation not taken.
I'll take 60 days limitation. I'll have limitation petition to that effect. This well covered. This well covered by my Lord Honorable Supreme Court. I have given a
This dispute from the tribunal went up to Supreme Court and set in favor of my client, my lord.
But the
And thereafter, I have filed the consequential relief for arrears salary. I have filed the writ petition against which they have come. But my order in the tribunal, the order was against the petitioners. He succeeded in the High Court, and High Court order was upheld by the Honorable Supreme Court. And thereafter, when arrears were not paid, I filed the writ petition.
The subsequent judgment of the Honorable Apex Court is squarely covered by that subsequent. I have given the copy, my lord, that in the case of State of Orissa versus Anup Kumar Senapati.
No, that has nothing to do in this case because this has been settled way back by the Supreme Court in 2016.
They are not implementing. Now they are filing the case.
I have given that copy, my lord.
No, but it's gone beyond the stage, he says.
I'll take step for limitation. 60 days.
Defect be cured. No, you say list on. 22nd February. Defects be cured in a minute.
Item number 42.
My lord, item 42 to 51, my lord, this writ appeal relates to that Sarat Parida case. A batch of writ application your lordship had already entered. I am passing the order copy, my lord. All these are posted to 8th of May, my lord. Similar order I am paying, my lord, similar.
All right.
Till 51, my lord.
All right.
Obliged, my
51.
lord.
Let's item 52 I pray for on Passover.
All right. 52 Passover.
52. Passover.
Item number 53.
May it please, my lords. 52, your lordship may kindly turn to your lordship's order dated 33/2022.
No, 52, he is already passed, asked for a Passover.
Oh, you're paying for Passover. Okay.
53.
Item 53.
52 Passover.
53.
53.
Yes. Can we have it at 2 p.m. then in that? Whatever. What?
All right.
Well, the industrial award is under challenge. Your lordship sometime passed the order on 22/6/2022 to know about the status of compliance of 17B. 17B has been complied in the meanwhile. Whatever the payment, we have made it. So now, my lord, I have submitted a brief fact in the other court of the case. But instead of going to that, if your lordship turn to the award is under challenge, my lord, the only for a period 1399 to 16/2002, they were DLR, daily rated worker, they were engaged. And that was, my lord, engagement was made in violation of the law. That means in section 73 of the Orissa Municipal Act, as that was then in the book. And subsequently, Orissa Municipal Corporation Act came in 2003. And their appointment is 1399 to 16/2002. Sorry, 2002. And my lord, there has been amendment also, section 73, that if there will be any illegal appointment in violation of law, that is ab initio void, that cannot be also any regularization. And to that effect, a circular was also issued by the government. And that is also annexed to.
Come to the order dated 19 December. Passed with this court, 19 December.
And that has been also complied. That has been complied. And also, my lord, they have received the amount. They have received the amount.
Come to that order, sir, para 4 of that order.
Para 4 of the award.
Order, sir, order passed with this court on 19th December 2022.
Yes.
Please read that order. Page para 4. You don't have that order. All right, just give it.
Excuse me, but
para 4 and 5.
That we have done. That we have paid at the rate, my lord, earlier, that was 1,200 rupees we had calculated. But from the award, that was 1,500. Accordingly, the difference of payment has been made.
When?
That was been made, but I have kept the receipt also. They have received from the office. Lordship, kindly see 9/1/2023.
23.
23. The receipts are there. They have
Received
received
record, which is why we're asking you.
that document. He admitted in the last occasion before the court. And the two cases, there are two cases, in two cases. So that, they have to see.
Mr. Mohanty has placed on record proof of payment having been made of the amount due to the workman as noted in the order dated 19th December 2022.
In both the cases.
Right.
In another case,
it's all
but here only.
Give it back.
Your lordship with digital. My lord, here only, my lord, the mic.
Notice gone. Where is Mr. Barrel?
Lordship.
You are appearing.
My lord, I am in the second sub item, my lord.
You are for the workman.
Municipal corporation, my lord.
I see. Who's for the workman, sir?
Municipal corporation is appearing in second case, first case and third case. I am for municipal corporation.
No, sir. Who's for the workman?
Workman.
Because the last time's order in 14759 shows that one Mr. Burrell is advocate for
yes.
workman.
Yes.
He's not here today.
He is appearing in all the cases.
Today he's not here. None appears for the workman today. In the interest of justice, let's stop. 9th August.
Item 9th August.
9th August.
Item 54.
In item 54, my pay my lord, tomorrow, your lordship can take it tomorrow, my lord.
What's the matter about it?
Regarding the challenge has been made to the order passed by the State Administrative Tribunal.
Yes, so there are three grounds in which the tribunal has held it in my favor. One was that your lordships.
Excuse me, interim order was there that may come in all this.
Was it there? If it's there, it will continue.
Yes.
Yeah, on three accounts, they actually has held it in our favor. One is your lordships, it was a post-decisional hearing. That means the chief minister actually had taken the decision of dismissal, and thereafter they sent this notice on the quantum. Second, your lordships, the second show cause notice which should come on the inquiry report wasn't there. Third point was actually the charges which were there in the memorandum charges were actually dropped and a third charge was made out. So they said that natural justice again was not followed. So these are the three counts. I don't know. There's no reason for it. And meanwhile, he's even retired. So your lordships, I'm ready with the whole thing.
I pray tomorrow or after lunch, your lordship?
Lordships, after lunch, I have a part heard matter.
All right. Counsel for the petitioner. Praise for a password which is not convenient to counsel for the opposite respondent. Opposite parties. See, this on 10th August, interim order to cut.
August, your lordships. I'm ready today, your lordships.
I know.
And there's hardly anything in it.
It's all.
Item 55.
Actually, your lordship, there's no stay. It's not been admitted.
No, that contempt, something.
Yes, contempt, your lordship.
No admitted, but they are not releasing any pension, nothing in my favor. That's the whole.
Dismissed from service have pension.
And your lordship will see there's a series of times. Always the state has been taking the time. That's the whole thing.
It's all right. Okay. All right.
Item number 55.
Right. None appears. Oh, you are there. All right.
55.
55.
Rungta.
Rungta.
May I please, your lords? This is an empty tax matter, my lord. This matter has been fixed for 6/2/2002 matter.
Your lordship, the identical matters have been fixed on 6th February. Your lordship.
All right. List on 6th.
Item number 56.
I'm pardon to mention, my lord. Today, item number 3, due to my traffic difficulties, I could not reach. Maybe taken up.
We'll take it up right now, sir. Tell us what it is about.
Item 3 now.
Tell us, tell us. Is again not accepting the revised returns. Is it because of technical difficulty?
Notice for assessment has been challenged, Your Lordship. Notice for assessment has been challenged, Your Lordship. The prayer,
Your Lordship, what happened? In this case, I have deposited tax, a sum of rupees. Annexure 7, 89 lakhs 31,691. And paying for filing of revised return, that portal was stopped.
No, what was the reason you could not file return?
Because the commissioner did not allow the portal.
No, for what reason? Was it delayed or what?
No, yes, delay for file. That was after this GST came into force. There is some delay.
What is the delay, sir? Tell us.
Delay of
What is the period for which you wanted to file this revised?
July ending 30th June 2017.
June 2017.
So what is the delay?
More than a year. This petition is filed on 27 June. It's a representation made on four. July.
Yes, yes.
So for
this is Your Lordship.
filed it on 24 July, sir. E-filing acknowledgement is that, page 36.
No, that is original return. Revised return he has not filed. Revised return, Your Lordship.
Yeah, so revised return, you have 1 year's time, no?
Your Lordship, revised return is 3 months.
What is it? 33.
Your Lordship, 33.4.
33.4.
Your Lordship. 33.4 is that he may file a revised return within 3 months following the tax period to which the original return relates. So, Your Lordship, here the revised return has not been filed, Your Lordship.
Because he couldn't get permission, he says, from the commissioner.
Your Lordship, this is the assessment year. This is the assessment period annual 16-17.
No, 30th June 2017.
I have deposited tax. 89
It's
lakhs.
for the return for the quarter ending 30th June 2017.
So, Your Lordship, here, Your Lordship, notice for assessment has been issued. So, he can ask this ground before the assessing officer, Your Lordship. Himself, Your Lordship. Because, Your Lordship,
he wants to file the revised return. He's not running away from that.
Your Lordship, the
Section 35 says filing a revised return does not empower the sales tax officer to call for the records. So only I am paying that already deposited the tax.
The entire tax amount has been deposited.
89 lakhs. And interest is 6 lakhs somehow, my lord.
Your Lordship, my instruction, so far as my instruction has been subject to Your Lordship's direction, that regarding instructions on filing and uploading revised return, it is pertinent to mention here that under the extant provisions, the dealers are filing their returns and revised return electronically through VITIS. And this office has no role to play in allowing or disallowing a dealer in filing a return or revised return. This office, Your Lordship, this instruction has been given pursuant to Your Lordship as directed. That portal, Your Lordship, has not been blocked to file the return. So he has
I have intimated the commissioner that I have deposited the 95.
Your Lordship, since deposit, you have to file the return, and your Lordship, there is no prima facie that portal has denied to file the return.
No, that's why he's come to the court.
As per the instruction.
No, there is a delay. He acknowledges there is a delay.
Your Lordship.
He wants to file a revised return. The only question is, can he be permitted or not? All the time. In July, are you aware of that?
Your Lordship, pursuant to that, the instruction I have received, Your Lordship, that pursuant to the 16th July order.
That to take instruction to allow the.
Let me. I have taken instruction, Your Lordship, and in the instruction, Your Lordship pointed out the same thing. I may be permitted specific instruction on this issue. I have often instruction, but that instruction is not satisfactory.
Except 12, is it necessary?
Counsel, the petitioner states that the entire demanded tax amount has already been paid, and he only seeks permission. He only seeks a direction to the Commissioner GST, CT and GST, to permit the petitioner even now to file the return for the quarter ending 30th June 2017. Mr. Sunil Mishra, Senior Standing Counsel, seeks time for instructions. Interim order to continue. List on 12th. 14th August.
Weekly list item 56.
56, my lord. I remember that matter.
I have filed an
Construction of the
affidavit.
people underpass. Pedestrian underpass at the point. Now, my lord directly, my lord's own order dated 20th April 2022. 20th April 2022 order may kindly see. May I please, my lord? 20th April 2022 order of my lord. Para 2, or the stand taken in the counter affidavit at the National Authority in India is that after completion of the project, construction of pedestrian underpass, PUP will be considered during operation maintenance period as per clause 16 of the concession agreement. Admittedly, the operation of the maintenance period is already underway. Mr. Amitabh Das, counsel appearing for the NHI, states that concessionary will be required to examine the area again, and if there is any school existing there, will come up with a plan for construction pedestrian underpass. In this rough sketch map, enclosed to the region, the possible location of such an underpass has been indicated. Concessionary will examine the feasibility of providing the underpass either at this location or any other suitable location to serve the need of the residents of the village, Chandanpur and other villages. This direction, my friend has filed an affidavit.
I have filed an affidavit on
My lord, kindly see that.
21/4/2022, my lord.
Yes, ma'am.
The lordship on to page 3. Page 3 of that affidavit, because in the meantime, 7 to 8 years have already been passed, my lord. The lordship may see page 3
But
of that
how is
affidavit.
this? It's all about safety, sir. How do you assess the safety like this?
No.
Have you been to that place?
No, my lord.
You should go yourself. You try crossing that place. Just stand at the end of one end of the road at this place and you try crossing.
No, that's why, my lord, I have, because this has been stated that the detailed project report consultant is proposed to be appointed because the earlier concessionaire has quit the contract in the year 2017, my lord. Thereafter, my lord, the NHI was
On the operation, I was looking up.
Ask whoever has sworn this affidavit
Yes.
to stand on one end of the road
Yes.
and time it, how long it takes for him to cross that road.
No, that's why
And do it at the peak hour, whatever peak hour, and with the vehicles passing at whatever pace, you ask him, because we are talking of pedestrian underpass, correct?
Yes, pedestrian underpass.
We will give him a special award.
Yes.
If he's able to cross that road.
No, that has been.
You tell him the two judges are prepared to give him a special award if he stands on that Puri Bhubaneswar highway and is able to cross the road comfortably.
Now the stand is, it is not a black spot, my lord. See.
That's why your lordship see Roman 7, my lord. Page 4.
Sir, there will be no need for all that.
Because,
ask the gentleman to just stand on that road.
Yes, my lord.
You take a video.
Yes,
you also go with him.
Yes.
Try crossing that road. Try crossing the road any time of the day. Try crossing it.
And now the stand is, there is no black spot.
No, we'll know how many spots are there. Once you try and cross it, all the spots will come to your mind.
School children will go.
That's why, my lord.
Villages will go.
If at all, my lord, it will be constructed, my lord. Pedestrian underpass has already been eliminated, my lord, from the national highways.
So you just
because
ask him, whoever this gentleman, who is this gentleman? Just ask him, Prabhat Kumar Singh.
Yes, my lord.
He's a project director.
Yes.
Ask him to stand at one end of that road and ask him to cross. No problem. If he's able to safely cross, in fact, he can keep 2 young children next to him and try crossing. Then all the spots, blackest spot will come.
They will say,
yes.
Declare it a black spot. It is not been declared as black
So
spot.
obviously, Mr. Das, you don't go to Puri.
Yes, madam.
You do. No, do you go or you don't?
Yes.
Speed.
You go to Puri. You don't look here or there. Only straight you look.
Man.
So you have no problem at all.
For some years, I was staying at Puri. Because my father was there.
So they want some death. People should lose their lives. Then will declare the black spot. That is the stand.
No, that is, my lord.
People will die.
Sorry, my lord.
Then they will declare black spot. They will consider.
That's why we have said, my lord, it will be placed before the DPR consultant.
There's no need for all that, sir. There's no need for all that. I'm just saying, ask this project director to stand. Yes. Next day, he will come and prepare a detailed note.
The fact that there is no accident as yet reported, it will mean that the safety will not be followed.
What may I suggest, my lord? Without recording my statement, my lord, lordship may direct the NHA to place this fact, my lord, before the DPR consultant.
What is DPR?
So that they decide the issue, because now the concept of PUP is not there, eliminated because of its small size. Now the vehicular underpass, they are going to be constructed. Now, your lordship, on the direction, your lordship has stated that either on the location suggested by the petitioner or anywhere it is convenient to the public, my lord. That's why they have said that in that location they have already created median opening on that spot, my lord. They have already been provided median opening in that spot. Safety measures has already been taken. Photographs have already been attached, my lord. So in that place, no space is there. It is just adjacent to an NH, my lord. There is no question of construction of any service road or underpass, my lord. It cannot be constructed because
pedestrian underpass.
Yes, it's pedestrian underpass. Then, for space is required, my lord.
What space?
How much space you require?
Because of its size, my lord. The pedestrian underpass, my lord, the size of the vehicular underpass, the minimum height, that height is not there in that location.
Say you don't confuse between pedestrian underpass and vehicular underpass.
Yes.
Don't confuse the two. We are talking of you have said no need to construct pedestrian underpass. Because that is your statement.
Now, madam, ministry is eliminated.
I think Odisha average height is not more than 6 feet. Even if you have 8 feet, let's say all our basketball players want to cross.
Ministry has eliminated the concept of pedestrian underpass from the national highway. They are constructing.
Pedestrians have no right to cross national highways.
They are using vehicular underpass, my lord.
So you make up your mind. What about pedestrians who want to cross from one end of the highway to the other? They have no right to cross.
No.
They have.
Yes.
And right to lose lives also.
No.
Yes.
That's the same. I don't understand what is this kind of approach. It's a human problem.
Yes, ma'am.
And you're treating it purely technical problem. I don't understand how you do this.
The Indian Road Congress, Butcher, I have seen other day.
Yes, I've given that. I do not dispute that. I do not dispute that because
2010,
That concessionaire is given that.
The court is surprised at the stand taken by the National Highway Authority of India
Project director filed there.
as indicated in the affidavit filed by its project director at Bhubaneswar in the affidavit dated 21 July 2022, wherein para 3 bracket Roman small 3, it is stated as under. Take from page 80. Paragraph. The further decision of the NHAI not to provide any pedestrian underpass on highways, open quotation, due to its small size, unquote, also is intriguing inasmuch as the need for the villagers on either side of the Bhubaneswar Puri section of NH 316 bracket old NH 203 bracket is real and not imaginary. Full stop. Paragraph. The court directs that the project director, EIU Bhubaneswar, will himself visit the spot at village Chandanpur, which he mentions in his affidavit, on any normal, on any day,
Working day.
on any day.
Sunday will be closed, schools will be closed. On any school days. Schools are other side, this is person on the side.
On any day, along with 2 young school children, and try crossing the road, try crossing the highway from one end of the highway to the other, and then file an affidavit indicating how easy it is for such young children to cross that highway without difficulty. Full stop. He may choose to videograph his experience and place it before the court. He may try doing so on any school working hours or just before the commencement and completion of school working hours. Full stop. This is because the court would like to understand the basis on which the NHAI has opined that there is no need for a PUP at this location. Full stop. The affidavit along with the video clips be placed before the court before the next date. List on it's on file. March 13th March. Mr. Das, you can also accompany him.
Yes.
Because then you will also have a realistic idea of what it is.
Yes.
My friend has given affidavit, they will consider during operation period. That is long past, my lord, observed in the order. Now, because
Vehicle list item number 58.
58, Lordship, on behalf of Mr. Mohanty, taken up next week.
What's the reason, sir?
Mr. Mohanty is arguing some other court.
So tell him 2 judges are waiting for him. Ask him to come, sir.
My lord, pass over your lordship.
That's a better way.
At 2 p.m.
That's the best. No. Don't dictate time and all. Just pass over.
Okay.
All right.
Item 58. Item 58 is a PIL matter. Today we are filing the affidavit for EMS. My lord directed to file. Already almost all it is complied with. it is found that he has given a false certificate. Thereafter, president has took a cognizance and his person was removed from the post of HOD. Today, we are filing affidavit.
Let me serve a copy.
How will serve the copy today?
He has been removed.
Yes, he has been removed for the post of HOD. We cannot remove the service, but for the post of HOD, we have removed. The assistant professor is appointed the HOD in this post, and disciplinary proceeding already been started. We have taken the specific environment.
Can't you suspend him pending disciplinary inquiry? Why can't you suspend him? Yes, submitted a false certificate, correct?
Yes, yes.
Then why are you keeping him in service? Why are you allowing him to function?
There is a strong support of the doctors. In each department, 2 or 3 officers are there.
False certificate also strong support of the doctors. Should I record that?
No.
Doctors are strongly supporting a person who has submitted false
We have
certificate.
immediately taken cognizance and we have removed from the post.
You are
of
not a
HOD.
magistrate taking cognizance.
Yes.
We are asking you, a person has submitted false certificate, you allow him to continue.
That part I don't have. Our instruction is that he has removed from the post of the proceeding has been started on the CSA.
Why is he not suspended pending completion of disciplinary inquiry?
May I pray the Lordship may keep you 10 days. Today we will file the affidavit. Then Lordship.
Where is your affidavit? Show.
Well, today we are filing, my lord. The second copy.
Deputy Solicitor General of India informs the court that the person in question has already been removed from the post of
from the post of HOD. Yes.
And that disciplinary inquiry has already been commenced.
Let's see the paragraph 4, my lord.
The counter affidavit is taken on record. Stop. The court would like the opposite party, Bhubaneswar, aims to explain why, after finding that the person has in fact submitted false certificates, he has not been placed under suspension pending completion of disciplinary inquiry. List on February 13th.
Obliged. And I'm sorry, my lord, I've given second copy, first copy I'm submitting.
No, you just file it, sir. Give it back. You just file it. The party states that he'll be filing the counter affidavit today.
Obliged. Mr. Behra is appearing with me. Let me reflect. PP Behra.
Item 59.
Here, the petitioner was granted with license up to 39/2018. Thereafter, his license was not renewed because he was suffering from cancer. And in the meantime, he has died. The legal heir has been substituted. But the closure period, the license period which has not been granted, that period they have demanded. But it is also covered by decision. But I have enclosed in the writ petition at page 37. It is there. Finding of this honorable court that if license is not granted, then there is no liability on the part of the license. And also your lordship's order is there.
No, but you normally go before the commissioner, no?
But here is covered your lordship's order. Lordships have disposed of in the light of the judgment. I have annexed also the judgment of the High Court, which is reflected in the lordship's order.
All right, that's IA for substitutions allowed.
Substitution not already allowed, I think.
But it's still showing, I don't know.
But I have filed consolidated, Miller.
All right.
Consolidated cost title I have already filed long since.
Stands disposed of by in terms of the.
Lordship allowed.
No, 16184.
Yes.
Disposed of.
Miller, 16184 is the substitution petition.
It's already been disposed of.
I don't know. I have filed also.
So, sir.
Yes, Lordship. Lordship that allowed.
That's what we're trying to do.
I'm sorry.
16184 allowed.
How many months?
And the main petition is ordered.
No.
October to March.
Your lordship may indicate the.
Yes, it has been written.
Yes.
I've corrected.
Item 60.
Hey, please, your lordship. Get the petitioner pray for closure of his OS shop, my lord, because due to the moist attack since 2003, the shop is closed, my lord. And the petitioner has made a representation under Annexure 3, which has been forwarded to the government by the collector at page, my lord, Annexure 5 at page 34.
Counsel, the petitioner states that the petitioner's representation to the government has been forwarded by the collector.
And now the excise commissioner has been forwarded under Annex 6. Page 35.
And also by the commissioner. Bracket, Annex 6. Full stop. A direction is accordingly issued
To the excise commissioner.
Yeah. No. To the secretary.
To excise commissioner to examine the matter and if he
The commissioner's already, that's page 35.
Page 35.
Direction is issued to the additional secretary, excise department, to convey to the petitioner the decision on the aforementioned recommendation made both by the collector and excise commissioner.
Yes, madam.
Within not on or before 1st March 2023. The court clarifies it has not expressed any view in the matter. Petition is disposed of.
Item number 61.
61 were not pressed.
Dismissed is not pressed.
Item number 62.
Covered by your lordship judgment passed in whether chokered is coming under the definition of cattle feed or not. No. Paragraph 18, your lordship.
All right. In view of the legislation of this court in State of Orissa versus Geeta Shri Industries Limited, AAR 2022 Orissa 161. The impugned order dated 17/12/2020 passed by the Commissioner of Sales Tax Orissa in appeal number SU-02/2011-12 under section 18 bracket 5 of the Orissa Entry Tax Act, as well as the order dated 15/12/2010 passed by the Joint Commission of Sales Tax in suo motu revision in the as a suo motu revision under section 18 bracket 1 of the OET Act are hereby set aside. The petition is disposed of in the above terms.
Both the matters also.
Yes. Oh, both matters, is it? Yeah, both matters. All right.
Item number 63.
May I please, your lordships?
Yes.
My lord, this matter relates to the, I am confining my prayer to the question of interest for the period prior to 31/1/2017. And that item, whether we are liable or not liable, will be decided by your lordship, and your lordship has given us
February.
date in
2nd
the month
February. All right. List on 2nd February. Right.
Much obliged, my lord.
Item 64.
Your lordship, I humbly pray for a pass over lordship.
All right.
Highly obliged, your lordship.
Item number 65.
May I please, my lords. So this is a matter, your lordship earlier was pleased to be direct by an interim direction not to finalize investigation, because my lords may kindly turn to page 18, my lords. Initially, by annexure 1 and 2, page 18 and 19, 2 notices are issued, my lords, for the purpose of investigating, requiring the petitioner to submit declaration forms in respect of interstate sales, C, F form and export also. F form, C form and H form, that your lordship will find from page 19. Thereafter petition complied. I have also annexed the copy of the all statements.
Yes,
that was verified. And I have with me, which I have not filed, I got later. Now this provisional assessment has already culminated with assessment. No order is formally communicated, but the original certified copy as it appears. Period, your lordship may kindly see. So I'm sorry, one copy I'm giving. I will read just this is a certified copy. They have not given me the order for 1/4/2013 to 2015, 31/3/2015, and other period is 1/4/2015 to 31/3/2017. For all these periods, now provisional assessment on the Central Sales Tax Act is over, my lords. My lords may kindly see.
So it's infractuous then.
Sorry?
The petition is infractuous then.
No,
because you have come at the stage of provisional assessment.
Provisional assessment. Now what has happened? By the annexure 5, covering the same period,
They have issued notice in form VAT 401, and my lords may kindly see that's annexure 5 is at page 35. Page 35. This is for the period, my lords, 1/4/2014 to 36/2017, covering same period except on additional period that is from 1/4/17 to 36/2017. And serial 11, C firm, F firm, all these. Now I wanted to know the reason why again mirrors for VAT when already investigation is over and assessment complete. May kindly see reason they have given page 41. Page 41 for this VAT mirrors. In view, last paragraph mirrors, page 41. In view of the above, it is to communicate that the investigation into the business activities of the dealer company has been initiated on the basis of the fact that the dealer company has dispatched the taxable goods to outside the state of Odisha on branch transfer, for which the dealer company has claimed exemption of CST in the CST returns for the period under investigation. Such branch transfer is required to be examined with reference books of accounts and other connected evidences in order to ascertain the truthfulness of the tax liability discharged by the petition company. Then also they say, besides the above observation, the tax liability of the dealer company, which may surface in course of year. So, because of this, your lordship will not directed that investigation may not be finalized. Because the Central Sales Tax Act, when the assessment is over for the very same period, and I have given all the C firm, F firm, H firm.
Only for 3 months. What is given is up to 31st March 2016. 17.
Yes.
So for 1/4/2017 to 30th June 2017.
Absolutely correct. So what I am submitting, your lordship may direct that let investigation for this balance period may be carried on and they may take appropriate course of
Your lordship, that is the investigation. Your lordship may kindly turn to the your lordship's order dated 22nd March.
Yes.
Your lordship, in the interim, your lordship, the enter grievance is that since annexure 1 and 2 are pending, the notice, the proceeding under section 12(1) of CST Act. So 8, 9, 10, the annexures which are issued under VAT Act, Value Added Tax Act, your lordship. So in the interim, it is directed further proceeding 5, 8, 9 shall remain state till next date. However, we direct that proceeding initiated against the petitioner under annexure 1 and 2 may continue. Result thereon may be known to the
1 and 2 are also under VAT.
No, your lordship. So under
CST Act.
Under CST Act, your
That is
lordship.
disposed of.
That is, your lordship may kindly look into the order sheet. I have submitted that proceeding has been closed, your lordship.
Closed, my lord. Yes.
That proceeding has been, it is a separate proceeding so far as the VAT Act is concerned. So it is the notice for assessment. So
No. He's aggrieved not by 1 and 2 alone, sir. He's aggrieved by that.
All the notices for assessment he has agreed. And he's
Annexure 5. Annexure 5 is a VAT notice.
Your lordship.
He's only pressing that now.
Your lordship. So his entire grievance is that since annexure 1 and 2, the proceeding under section 12(1) of CST Act is pending, so the VAT Act on the same issue, the notice under VAT Act cannot be issued.
No. He's now pointing out, as far as VAT is concerned, you've completed your assessment.
No, your lordship.
No,
under CST completed. Under CST completed.
12(1)
CST, your lordship.
But very same issue, branch transfer.
No, lordship.
They have given the reason now. At page 41, I read out for lordship, my lords. They, my lords, while issuing 401 notice by annexure 5, they want to examine the transaction concerning branch transfer, which has now already been examined by the very same officer by notice dated 1 and 2, culminating in assessment, which I just passed on to us.
Your lordship may kindly turn to page 35.
Right, your lordship says for balance period they can do.
Besides the forms, all other documents have been called for. Your lordship, it is the assessing officer's jurisdiction to verify all the documents and to complete the assessment. And the assessment under VAT Act, it is notice.
For branch transfers, once there is a CST assessment order, which is again examining branch transfer.
Not branch transfer. Your lordship may kindly page 35. Page 35, the notice under VAT Act.
No, but the reasons given by you. Just come to the reasons. Yes. Come to the reasons given by you.
Page 41. Yes.
No, 41 is the investigating report.
No, reason.
No, that. Your lordship, 30
enforcement.
Enforcement. That is enforcement. That is separate, your lordship. So, your lordship, this is the bad notice for value of VAT assessment, your lordship.
Come to page 41, sir.
Your lordship.
This is for explanation for that VAT notice. VAT 401 notice, they're giving the reasons why they issued that notice.
VAT notice is by investigating unit, not by the assessing authority.
Your lordship.
But the balance period they can.
41 is equal
balance
to
period.
page 35. Page 35 is Joint Commissioner Commercial Taxes Enforcement Range. So that is sequel. He has given the reason.
That is for period, Your Lordship.
Again for the same thing. You see, the petitioners aggrieved by the issuance of a notice in Form VAT 401 dated 30th November 2017 for the period, asking the petitioner to produce books of account for the period from 1st April 2014 to 30th June 2017. Paragraph. Mr. Jagavant Sahul and its senior counsel for the petitioner has produced before the court copies of the assessment orders passed under the CST bracket O rules for the period 1st March 2013 to 31st March 2015 and 31st March 2013.
One for 2012
one for 2015 to 31st March 2017 pursuant to the notices.
But may I clarify? One period is one for 2012 to 31/3/2013 and one for 2015 to 31/3/2017. Is split up form. That is
for the periods 1 for 2012 to 31st March 2013 and 1 for 2015 to 31st March 2017.
And the other one is 1 for 13 to 31/3/15. Two orders are there.
Right. And for the period 1/4/2013 to 31st March 2015, pursuant to notices issued earlier and annexes 1 and 2 to the petition. Paragraph. The reasons for reopening, the reasons for the issuance of the form notice under form VAT 401 dated 30th November 2017 have been provided to the petitioner by the Joint Commissioner of Commercial Taxes Enforcement Range by a letter dated 25th January 2018, bracket Annex 8.
By the sales tax office of the Joint Commissioner. The last
All right. By the sales tax officer, investigation unit, Sambalpur. All right. The said reasons read as under bottom of page 41 and top of page 42. Paragraph. In view of the fact that the notice has been issued, in view of the fact that the notice, the reason for issuing the notice is regarding the claim of the petitioner regarding branch transfers, which issue for the aforementioned periods stand covered by the assessment orders under the CST bracket O bracket rules. Now for the period from 1st April 2012 to 31st March 2017, the justification for the Form VAT 401 notice is valid only for the remaining period, that is 1st April 2017 to 30th June 2017. Paragraph. In that view of the matter, it is directed that the petitioner will now produce before the Sales Tax Officer Investigation Unit, Sambalpur.
Now there is office in Bargarh, investigation unit Bargarh since 2020, I think it is there. Earlier it is Sambalpur, now it is at Bargarh.
Which is now stated to be at Bargarh. The books of accounts for the aforementioned period, that is 1st April 2017 to 30th June 2017. For this purpose, the authorized representative petitioner will appear before the said officer on 1st March 2023 at 11 a.m. Full stop. No further directions are called for. The petition is disposed of.
Maybe appropriate Bargarh.
Right.
Your Lordship.
Item number 66.
Your Lordship, this
in
item
item
66, 67 and 68, Your Lordship. In all these cases, some of the cases, Your Lordship, pleadings have been completed. And some of the cases, I am filing the counter on today, Your Lordship.
Correct.
Your Lordship, here the issue is that, Your Lordship, my respectful submission before Your Lordship is that a date may be fixed for final disposal of all these petitions, Your Lordship, so that all these petitions can be disposed of at a time. And in the meantime, all the pleadings to be completed, Your Lordship.
Order to continue.
Your Lordship.
All right.
68, my lords, last sub item. I'm appearing in the 68 last sub item, my lords. I'll file the counter also in the meanwhile, my lords. I may be granted a week's time, my lords, and file the counter.
All right. Counter affidavits filed by all the opposite parties who have not yet filed on or before 3rd April 2022. Majority that to be filed for the next date. Interim orders to continue. List on 18th August.
Obliged.
Sorry, on 21st August. Sorry, 21st August.
Good for me.
66, 67, 68.
Yeah, 67.
My lord, distribute early.
You have correctly understood.
It is good that he has taken time. Where in the morning, I was very much sicky.
Okay.
To argue before your lordship or not. Seeing the court of the mood is not in a. So,
all right.
May I make another attempt?
Yes.
For an early date?
No. You have an interim order, sir, in your favor. So,
my lord, in item number 68, 23067 of 2022, my name may be reflected in the cause list.
All right.
I have already filed the memo of appearance.
All right.
My lord, item 67 and 67 covers that also, my lord.
That's right.
Item number 69.
69, may I please, your lords? This is a sales tax revision for the period.
No. 69 is something else.
69 excess.
69.
69. 55573 of 2015.
None appears deceased.
Item number 70.
My lord, item number 70 is infructuous, my lord.
Infructuous dismissed. All right.
Item number 71.
71 short supply matter.
Your lordship, in item 71, I am appearing for the OP number 6.
All right.
My appearance may be noted.
Covered by that.
Only demand notice date has been corrected.
All right. Same order.
Item 72.
Liberty may be granted to file an appeal.
I see. Counsel, the petitioner seeks leave to withdraw the. There are two matters.
Yes, my lord.
Both these matters. The liberty to file an appeal in court of law. Such appeal is filed not later than 1st March, accompanied by an application for convention of dealing. Usual thing. The originals be returned subject to attested photocopies.
Obliged.
Item number 73.
73 is audit objection matter.
Covered. Same order.
Item number 74.
Mr. Patra.
Yes. 74.
74. Aruna.
But 74 not pressed.
Not pressed. Dismissed is not pressed.
And 76 will also. 76 not
76
pressed.
also. Dismissed is not pressed. All right.
75. Item 75.
None appears dismissed.
Item number 77.
May I please, your lordship? The petitioner belongs to scheduled tribe person, my lord. The Lord and Single Judge has applied the principle of res judicata in arriving the conclusion. Kindly see paragraph 6 of the impugned order.
Yes.
Kindly see paragraph 6. May I read, my lord?
Yes, please.
The court, whether the second successive petitioner involved the same properties involving the impugned orders after dropping of the first round litigation between the parties initiated under the provision of Regulation 2 of 56 is maintained or not. Coming to the conclusion framed herein above, looking to the observation already made herein above, this court finds that the petitioner has clear case
all through that involving the transaction of first round litigation, the opposite party initiated the proceeding by Regulation 144 of 97. Following the provisions under the Regulation 2, where 1956 admitted the said proceeding was dropped. After considering the dispute properties, that dispute involved therein, and on merit involved therein, this being the admitted position, there being no material available, that any challenge was made by the opposite party 6 and 7 involving the orders passed in the Regulation 144/97. The order passed by the competent authority under the Regulation 2/95 involving same property. My summary lordship, my lord, the Regulation 144/97 belongs to my lord, the plot number 385, that annexure 3. But my fact is, my lord, Regulation 1 of 95, that is plot number 317 and 380. Lordship, kindly see the impugned order. That the difference.
Who's appearing for respondent number 1?
That different cause of action, my lord. It cannot be
respondent been served.
Private respondent is to answer.
Has a respondent 1 been served? Just see.
It cannot be a principal original cannot apply to this case, my lord. But because both are
Lot numbers are different. All right.
6 and 7 before the
subject matter is Regulation 1 of 95 belongs to 3 plot number 379.
private respondent ko notice serve hechi.
They
have appeared. What he says that they have appeared to counsel. They
have not stated anything. They have filed the affidavit. They have not stated anything.
What your lordship will find from the impugned order, the only ground on the basis of which is retribution, that is barred by res judicata. For the self-same. Now he is saying that that was for this different plot. This is for the different plot.
That annexure 3 is 144. That plot on 385. But my case is 379 and 380 belongs to Regulation 1 of 95. That cannot be.
So let's go back. You'll have to go back then.
He will examine this fact, whether this the earlier case relates to the same plot
or
in respect to which the second.
No, it said.
He will examine.
He said none appear for the respondent number 1 bracket as substituted by her LRs bracket. Stop this court has heard submissions of learned counsel for the petitioner as well as the state. Paragraph. The challenge of the present appeal is to an order dated 14 March 2017 passed by the learned single judge dismissing the petitioner's writ petition civil 4481 of no. What is your
that is 19010
judgment dated 1st November 2016 passed by the learned single judge allowing
Yes,
allowing writ petition civil 19010 of 2010 filed by the respondent number 1 seeking the quashing of an order dated 22nd September 2010 passed by the additional district magistrate Sundargarh in revenue appeal number 23 of 2002 and the order dated 12th April 2002 passed by the sub-collector Bonai in regulation case number 1 of 1995. Stopped by the impugned order, the learned single judge, while allowing the writ petition, set aside the aforementioned orders. Paragraph. According to the learned single judge, the plot given to the respondent number 1 by virtue of a registered gift deed already stood covered by an earlier regulation case 144 of 1997 and therefore a second case in relation to the same property was not maintainable. Paragraph. On the other hand, it is the case of the present appellant that the property in question is Sabic plot number 203.
Corresponding to plot number 379 and hall plot number 380.
Corresponding to
hall plot number 379.
Hull plot number 379
And hull plot number 380 of area 9 decimals.
Yeah. Was not the subject matter of the earlier proceedings.
These are subject matter.
According to him, that was a separate plot. And therefore, the principle of res judicata could not have applied. We stop. The earlier proceedings, according to the petitioner, was in respect of plot number 385, corresponding to khata number 13, paragraph. The perusal of the impugned order of the learned single judge reveals that the above facts were not noticed by the learned single judge. Full stop. In other words, the contention of the present appellant that the present dispute concerns plot number 379 and 380, whereas the earlier dispute, which ended in orders in favor of the respondent number 1, were in respect of plot number 385, corresponding to khata number 13, was not addressed. Full stop. Paragraph. Although an affidavit has been filed on behalf of the LRs of respondent number 1, there is nothing therein to contradict the above assertions of the petitioner as regards the subject matter of both proceedings. Paragraph. In that view of the matter, the impugned order of the single judge is set aside, and writ petition civil number 19010 of 2010 is restored to the file of the learned single judge for now being decided afresh on merits after hearing the parties. Full stop. The matter will be listed before the roster bench of the learned single judge on 27th March 2023 for being proceeded with afresh in accordance with law. Full stop. Till the disposal of the writ petition, status quo shall be maintained by the parties. Who's you're in possession?
I am in the position, my lord.
All right. Status quo shall be maintained by the parties. All right.
At note 78.
Actually, subject matter, my lord, regulation 1 of 95 belongs to, my lord, the plot number 379 and 380. And 144 is not there, not in the picture. But subsequently, he has the first time he has raised this this point before your lordship.
That will be examined by the honorable civil.
All right.
At note 78.
My pleasure, Lordship. After hearing the matter by last order, your Lordship.
78, I am appearing for respondent 1, 3, 5 and 6 today.
There is delay. There is delay in filing the appeal. After hearing the matter, your Lordship was pleased to issue notice on the question of delay and also admission.
What's the delay?
Stay matter. Delay of 138 days.
138 days. What's the explanation of the delay, sir?
The impugned judgment was passed in the when there was non-representation for the present appellant, and after coming to know about the disposal of the writ application, the appeal was filed.
No. When did you come to know?
But after the writ petitioners communicated a copy of the order was passed.
All right. The delay is condoned. You just say, for the reason stated therein, the delay in filing the writ appeal is condoned. Miss case number 182 of 2018 is allowed. The writ appeal number 109 of 2018.
I am appearing for the 1, 3, 5 and 6 respondent.
He appears for respondent numbers 1,
3, 5 and 6.
3, 5 and 6. Stop. Has it been served on the rest? 2 and 4. They've been served. 2 has been served. What about 4? As far as respondent 2 is concerned, service is complete, but none appears. So as far as respondent 4 is concerned, the undelivered notice has been returned with the report open quotation addressee is out of India on the same day, full stop, hence returned to the sender, full stop, unquote. Paragraph, the appellant will ascertain the present correct address of respondent 4 and file it with the registry within 4 weeks. Thereafter, fresh notice to respondent 4. Returnable. August 14th.
Well, let there be stay of the impugned order, my lord.
Last time there was no stay granted.
No, because my lord, last date there was limitation. Therefore, your lordship issued
So
of the question
nothing is happening. What is happening pursuant to the impugned order? Nothing. It's all right. Yes.
Item number 79.
Obliged.
May I pray, your lordship? You kindly have that impugned order at page 10. Here, my lord, admittedly, the petitioner could not produce certain documents in the original proceeding and which he wanted to introduce in the writ petition. Kindly have that impugned order. In the event he was unable to file the document in the original stage, even after the remaining unsuccessful in the appeal, the petitioner got an opportunity to seek such relief in the revision, and the petitioner failing to do so has lost his right. In the circumstance, the court had no occasion to consider such document.
This is 227. How is the writ appeal maintainable?
My lord, I have the decision of the Honorable Apex Court which says that the new document considers.
No. How is this writ appeal maintainable?
No, my lord, it's arising out of OPLE proceeding.
This is arising out of a
OPLE proceeding.
OPLE proceeding.
OPLE.
So, Honorable Single Judge has said that you did not produce the documents before.
No, this is not a 227.
Well, no, in
The
226.
just said that.
No, it is 226 and 227. Your lordship can have that decision.
OPLE proceedings.
OPLE proceedings, I mean.
But last paragraph, last line of the impugned order, page 10.
Lordship, paragraph 6 of the report.
That's right.
My lord. Now, what is the document, my lord?
Sir, how is a writ appeal maintainable against that order is the question. Once it is 227, how is a writ appeal maintainable?
My lord, it is 226, my lord. Because
No. Even this judgment says 227.
No, my lord, that is
in happened, my lord, in this case, for a particular piece of land in 1989, OPLE proceeding was initiated. That was culminated in a revisional authority before the ADM. ADM has said that the OPLE proceeding is not maintainable because he has got some subsisting right under the OEA Act. Therefore, the OPLE proceeding is to be dropped. And accordingly, Tahsildar also is last occasion I took adjournment to obtain instruction. So after 20 years,
my lord, may I just place your lordship paragraph page 12?
After 20 years, for the same plot, another OPLE proceeding.
The revision.
That was the Honorable Single Judge said that you should have produced all these old records of 1988-89 before the original authority. But these are the facts which we obtained from the
and in the counter affidavit also it is admitted.
There was previous proceeding, and in the previous proceeding, it was held that the OPLE Act is not to be implemented or.
All right. In the counter affidavit filed by the opposite parties, there is an admission that.
No, that is not denial. There is
there is admission of previous proceeding, paragraph 7, my lord.
Yes, there is an admission that earlier encroachment proceedings had been sought to be initiated with a EC case number 7/1987-88 under the OPLE Act,
which ended before
in the appeal filed by the
revision, which ended in revision before the ADM Keonchar,
which ended in a
OPLE revision.
6 of
encroachment revision number 6 of 1989.
I'm sorry. By order dated 21/8/95, I think.
It was disposed of by order dated 21.
Which stood disposed of an order dated 21st August 1995 of the ADM. Full stop. In that order, the ADM came to the conclusion
Paragraph, page 19, considering all the facts, instant case encroachment case is not maintainable.
Where is that?
My lord, page 19, paragraph
That
3,
the
considering all the
case
facts.
was not maintainable, but remanded the matter to the
Tahsildar
Tahsildar
to
for
initiate a
examining,
proceeding under the OE Act
for examining if a proceeding under the OEA Act should
for
be
settlement of the land. That is there.
for settlement of the land should be initiated. Paragraph. It appears that unmindful of the above development, for the second time, another proceeding under the OPLE Act was sought to be initiated against the petitioner, which was obviously not maintainable. Paragraph. The learned single judge has declined relief to the petitioner only on for the reason that the petitioner had failed to produce the relevant documents in support of his plea that matter already stood decided in his favor in the above proceedings under the OPLE Act, and that it had been held that the said OPLE Act was not even maintainable, was not, could not have been invoked. Full stop. Paragraph. Having heard learned counsel for the parties and having perused the counter affidavit filed by the respondents 2, 3, and 4 in the writ appeal, the court is satisfied that there is no dispute regarding the non-applicability of the OPLE Act as was decided by the ADM.
Lordship may
In
see
revision
page
case number
25, Annexure 4, that is of the Tahsildar's
6
order.
of 1989. Full stop. In that view of the matter, the impugned order of the learned single judge is set aside. And the order dated 6th May 2016 passed by the Tahsildar Kyunjar in encroachment case number 4446 of 2015-16, as well as the order dated 15th December 2016 passed with Sub-Collector Kyunjar in encroachment appeal number 5 of 2016, and the order dated 21st April 2018 passed by the Collector Kyunjar in encroachment revision case number 4 of 2017, followed by the letter dated 2nd January 2019 of the Tahsildar Sadar Kyunjar, are all hereby set aside. The writ appeal is allowed in the above terms and order systems.
Item number 80, obliged.
May I please, Your Lordship? Let the order dated 18/4/2019 passed by the learned single judge in WPC number 19358 of 2018 is impugned in the present writ appeal. My lord, the learned single judge has dismissed the writ petition, my lord, on the ground of delay and laches, because the petitioner, my lord, who is now a practicing advocate, at the relevant point of time, he was the development officer in New India Assurance, my lord. A departmental proceeding was initiated against him, and my lord, after that, my lord, he was removed from service in 2004, my lord. 26/2004, he carried an appeal, and the appellate authority also confirmed that order of removal on 1/2/2005. Both those orders were challenged in 2018 writ petition. On learned single judge has opined that the writ petition suffers from delay and laches, and on that ground only, my lord, without going into the merits of the case, learned single judge has, my lord, dismissed the writ petition.
So you have nothing to say then? We'll dismiss the writ appeal.
No, my lord. My lord, just my lord, that is the ground of dismissal, my lord. Lord, the original charge in the was that, my lord, he has, my lord, misappropriated sum of rupees 36,000.
So what is the ground of dismissal?
Dismissal that, my lord, he has misappropriated.
What is the ground of dismissal of your writ petition, sir?
On the ground of delay and laches, my lord.
What do you have to say on that?
My lord, it has, No doubt, my lord, there has been delay in filing the writ application, my lord.
What delay mean? How much delay?
My lord, order dated 26/2004 and 1/2005 was challenged in 2018.
You tell us, I'm very poor in arithmetic. You tell me, how many years delay?
My lord, 13 years delay, my lord.
What is your explanation?
That explanation was that, my lord, as the petitioner has mentioned, my lord, earlier he filed writ application, but that was withdrawn. My lord, withdrawn because of the communication gap between him and his conducting counsel, my lord.
What does that even mean, sir? He's himself a counsel. How can there be a communication gap? Virtually, there's no explanation. You say the present writ appeal is directed against an order dated 18th April 2019, passed by the single judge, dismissing writ petition civil 19358 of 18, filed by the present appellant on the ground of delay in laches. Paragraph. By the said writ petition, the appellant had sought the quashing of an order dated 28 June 2004, passed by the Regional Manager, New India Assurance Company Limited, in disciplinary proceedings against the appellant, which ended in dismissal from service. Also challenged in the said writ petition was the appellate was the order dated 1st February 2005, passed by the appellate authority, rejecting the appellant's appeal. Paragraph. In writ petition civil 19358 of 2018,
The order, my lord, I'm passing.
it is sought to be explained by the appellant that initially he had filed writ petition civil number 5711 of 2005, in which the respondents pointed out that an ID case number 13 of 2006 had been registered in the CGIT Bhubaneswar. It appears that the said writ petition was then dismissed as withdrawn on 14 July 2008. Without any leave for preferring any alternative, no, without leave to invoke any alternative remedy. Paragraph. As it transpires, the award dated 30th May 2012 by the CGIT Bhubaneswar went against the appellant, leading him to file yet another writ petition civil 25350 of 2012, which again was withdrawn on 18th May 2018. Full stop. Paragraph. It appears that the appellant had already availed the remedies, aforementioned remedies, and therefore filing yet another writ petition on the same cause of action was not legally sustainable. Full stop. Therefore, notwithstanding that a third writ petition was obviously barred by laches, in view of the above developments, it was in any event not maintainable. Paragraph. For the aforementioned reasons, the court is not persuaded to interfere with the impugned order of a single judge. The writ appeal is accordingly dismissed.
Passed on matter, item number 11.
11. After lunch.
Item number 12.
These are batch of cases, Lordship, is to remit back to appellate
Commissioner.
Commission.
She wanted a time. Pass over again.
Item number 52.
May it please, members. The Lordship's order dated, Lordship, may kindly have a look at your Lordship's order dated 33/2022. I'll just take some time to place, my lords, from paragraph 3 onwards.
Yes.
The issue concerns the expression 151 were supposed to be employed. The tribunal confined the relief to 8. The issue concerns the expression disputed workmen. Without categorically answering the issue framed for the tribunal to address by this court, that is whether IFCO is liable to give employment to all 151 workmen, the tribunal seems to have indirectly restricted the relief to only 8 workmen by describing them as disputed workmen. Mr. Das, learned counsel appearing for 51 of such workmen, as well as Mr. Singh, learned counsel appearing for 51 workmen, make a
another 51.
Another 51. I'm sorry. Make a grievance that their clients are ready with additional evidence to be adduced as proof of their employment with Messrs. Oswald before it was taken over by IFCO. Their grievance is that no opportunity was given by the tribunal to them to place the said evidence before it. Therefore, my lords, your lordship, in paragraph 5 held that with a view to obviating a further remand which will delay the matter, the court considers it appropriate to direct as under. The workmen who wish to be reinstated in service and who have not crossed the age of superannuation shall present themselves before the General Manager IFCO at Paradip between 18 and 22nd April 2022 with all relevant documents. 2. The General Manager will arrange to have these documents checked and verified. It will be open to the IFCO if the documents are found to be in order to either offer the workmen whose identity is established reinstatement or compensation in lieu of reinstatement. This is without prejudice to the rights and contentions of both the workmen as well as IFCO. It is expected that at least some of the issues that the workmen might get settled in that process. Third, this is important, a written report of such proceedings be placed before this court by the next date, list on 21st June. Then, my lords, on 21st June, your lordship, my lords, the order. Mr. Sarangi, learned counsel for the petitioner, states that 61 workmen had approached the management pursuant to the order passed by this court on 30th March 2022. According to him, of the said 61 workmen, around 15 have already attained the age of superannuation. He has prepared a chart for the remaining 46 who have given their particulars, including the Provident Fund slips, pay slips, appointment letter, and so on. He needs some more time to verify the Provident Fund details from the Provident Fund office. Learned counsel for the workmen, on the other hand, insists
that there are certain other persons who are outside the Orissa who could not reach in time to appear before the management on the date stipulated by this court. That is between 18th and 22nd April 2022. He states that he will file an affidavit providing the details of such persons. In those details, if those details are provided to Mr. Sarangi, learned counsel for the management not later than 27 June 2022, then Mr. Sarangi will further verify the details along with the details of the 46 persons and prepare a final chart not later than 10th August 2022. List on 17th August. Then, my lord, 17th August, at the request of Mr. Sarangi, learned counsel of the petitioner, who states that he needs some more time to finalize the list of eligible workmen, list on 2nd November 2022. Then, my lord, 2nd November, my lords, my lords, the submission was made that the list was not prepared. And then, my lords, it was submitted that they wanted to argue the entire award, the merits on the merits. But then my lords,
how many workmen were found eligible?
This interim order has to be complied with. That is my sole submission.
You still have not prepared the list of eligible.
Yes, my lord. That list has been prepared, my lord.
Where is that?
My lord, with due respect, my lord, when the matter was taken over before Justice Sinha, my lord, the entire matter was heard. The Honorable Judge wanted to pass an order. At the time, Mr. Counsel appeared and said that no, the matter should not be heard here. And it was
I beg to correct my learned senior.
No, I agree.
Please don't mistake facts.
And the
submission was made that once this interim order is there, that has to be complied with. Thereafter, hearing can commence. It was only that on that issue.
No, this interim order according to you has not been complied with.
Yes,
No,
yes.
not yet.
The list is there. If you also kindly see.
Today they are passing on the list.
I see.
List is there, my lord.
Then, so what do you have to say on this list?
We don't have a copy of the list.
Oh.
Just now they...
No, just because I have to go give it in the court.
Your Lordship knows this is grandstanding the issue.
Don't try to...
No. So will these people be taken back as the question?
That is
No. This is the list that has been prepared by your Lordship said. As per the things were directly your Lordship to work out.
How many eligible persons? That was the whole question, sir.
Yes.
If these many people are eligible, then they're entitled to the benefit. That's the whole question.
But I have,
if you confine it to 8 people, you are agreeing that
8 people were there as per the original order.
No. Now there are 56 who satisfy the same requirement. Whatever yardstick you have devised for recognizing those 8
with
people.
due respect, let me clarify. If your Lordship direct 25F to be complied with, so all the workmen, that will be done. But we have to do that because it's a case of 20 years ago.
Correct.
But and that too is a change of management.
Correct.
But that is how the dispute arose, and they found that
It's
8
all
people
list pendants. Yeah, that's right. You've taken over subject to all this.
Yes.
The petition is already pending, sir.
Yes, my lord. Well, therefore, if Lordship direct 25F to be complied with, that will be complied with, my lord.
All right. Pursuant to the orders passed by this court on
56 are now eligible, man.
30th March 2022.
56 months. So let them employ 56.
And the further orders, the exercise of verification of the details provided by the petitioner workman as well as the intervener workman have been verified by the management, that is IFCO at Paradip. And today in court, Mr. S.P. Mishra and senior counsel appearing for IFCO has handed over a list containing names of 56 such workmen who are admittedly similarly placed as the earlier determined 8 workmen, 8 single quotes disputant workmen, unquote. Stop. Paragraph, Mr. Mishra and senior counsel informs the court that in respect of these 56 workmen, the present management of IFCO is prepared to comply with the requirements of Section 25 capital F of the Industrial Disputes Act 1947 in a time-bound manner.
Leftover service also indicated.
Yeah, that's already there.
Yes, yes.
This is in the context of the chart handed over today in court indicating the number of years of single court's leftover service unquote of each of the said 56 persons. Paragraph, the court accordingly directs that in respect of the 56 persons in the list produced in court today, the petitioner IFCO will comply with the requirements of Section 25 capital F of the Act within a period of 12 weeks from today.
Slightly more.
Both the writ applications. Because one filed with management, one filed by the union.
Time span maybe little shortened.
Shorter. 12 weeks is fine. All right. The petitions are disposed of in the above terms. All right.
It's relating to the rest.
No.
Relating to the rest, my lords.
Rest.
This is 56. 151 had.
Which is why the whole exercise is undertaken. You'll all have to have documents. Whoever had documents, you will get the list, not otherwise.
Yes.
All right. All right.
Passed on matter item 64.
May it please, my lords?
Yes.
Plus, this is challenge to the constitutional validity, my lords, of section 194A.
The writ petitions are kept alive. This is the
No. Disposed of. Disposed of. If there's any non-compliance, you can always file whatever petition. Right.
64. May I please?
Yes, please.
Because this is challenging the constitutional validity of section 194A3, Roman 3, Milots, insofar as it creates a discrimination in the treatment of interest insofar as TDS is concerned, qua banks vis-a-vis, Milots, the NBFCs. Now, insofar as banks are concerned, Milots, and cooperative banks, Milots,
Where's the counter? No counter filed.
no counter filed as yet.
Mr. Party?
No.
Oh, you're appearing.
I am appearing.
Counter has to be filed, sir. Constitutional validity.
Perhaps
The act is very clear. Act is very clear.
No. Okay. Act is clear, which is why he's challenging the act.
File within.
Perhaps the union also has to file a counter.
No, he's appealing for Union of India only. You're for the Union of India or for the...
Yes, sir.
Very good.
Since the... No, but why should recovery and all be stayed? I don't understand. The assessment order should be challenged in accordance with law.
In the first appeal.
No. Milots, that's a different issue. Milots,
Then that's why we'll treat a different issue.
No.
We'll deal with your...
This challenge, Milots, arises out of the assessment order.
Naturally.
I'll tell your lordships why.
Yes.
Milots, the demand has been raised against me under section 40A IA.
Right.
Where the payments that I have made to NBFCs, why TDS was not deducted on that.
Right.
Therefore, Milots, section 40A IA.
You pay, we'll vacate the stay, whatever you pay.
No, we have already paid. Milots, if your lordship will give me a short date, I'll bring that on record. We have already paid amount of around 20%, which is required for.
No. Then you go in the first appeal. So you can't have two horses going like
No, Milots. Then your lordships, may I just request, Milots? In that event, Milots, the only thing I cannot further challenge the constitutional validity, Milots.
No, we'll keep alive. We'll give you a full judgment on constitutional validity, but we're not passing interim orders like this. Yes.
Very well. In that event, Milots, the only thing, your lordships, I'll apprise your lordships how much we have paid in the meanwhile.
No, that doesn't matter. You whatever you pay in the assessment proceedings will be subject to the outcome of this writ petition. That's all. That's the only relief, interim relief will be granted.
Very well. Milots may observe that.
All right. You see, the challenge in the present petition is both to the constitutional validity of section 194, capital A, bracket 3, bracket Roman small 3 of Income Tax 1961, as well as an assessment order dated 25th October 2017, passed by the Assistant Commissioner of Income Tax, Circle 1, bracket 1, Cuttack, for the assessment year 2012-13, raising a demand of rupees 1979,300. Right. While directing notice to issue in the present petition on 9th April 2018, this court stayed the recovery of the aforementioned sum from the petitioner pursuant to the aforementioned assessment order paragraph. The assessment order is obviously an appealable one. Full stop. While this court is still prepared to entertain the writ petition as far as it challenges the constitutional validity of section 194 capital A bracket 3 bracket Roman small 3 of the Act. As far as the assessment order is concerned, it is an appealable one, and the petitioner has an efficacious alternative remedy by way of an appeal. Full stop. Consequently, the interim order passed by this court on 9th April 2018 is vacated, and it is directed that any sum paid by the petitioner pursuant to the impugned assessment order would be subject to the outcome of the present writ petition. Full stop. Needless to mention that this order will not prevent the petitioner from questioning the said assessment order by way of the statutory appeal as provided under the Act. Full stop. This case number 822 of 2018 is accordingly disposed of. Paragraph in writ petition civil 915 of 2018. You see Mr. Chimanka appearing for the Union of India as well. Both Union of India and the department states that counter affidavit relevant to the challenge to the validity of section 194 capital A bracket 3 of the Act will be filed positively within 8 weeks from today. Rejoinder that to be filed for the next date. List on 16th August.
16th August?
Yes.
Well, can it be this side of the vacations? It's all fine.
All right.
Since your lordships have vacated, or any which way, the first appeal amount I have deposited. So
correct.
Grateful. I have also had a date chart is there on record for your lordships.
All right. It's there. It's there with us.
Grateful.
Right.
Great. Weekly list. All matters. Item number 1.
In this case, my lord, if your lordship pardons me, may I only pray that this may stay on board till Thursday, because my learned senior Sri Surya Prasad Mishra was conducting the case. Now I have been asked to conduct the case. I need little homework. I may be pardoned. I must be honest that I have not been able to do my homework. May I pray for Thursday? Let it stay on board.
All right. Stay on. All right.
Grateful, my lord. Grateful, my lord.
Item number 2.
May it please your lordship. I am VC, your lordship.
Yes, please.
This matter relates to the legal heirs of the deceased workman, your lordship. Because this award award dated 31/3/2011, which is at Annexer 2, is under challenge. Your lordship, it was the reference under the Working Journalists Act through the Industrial Disputes Act, your lordship. That was first made to the Labour Court and thereafter to the Industrial Tribunal, your lordship. It was transferred. Now, your lordship sees, let's have a look at the reference, your lordship, which is at page 17, your lordship. Whether Mr. J.N. Pradhan is a newspaper employee as defined under section 2C of Working Journalists and Other Newspaper Employees Conditions of Service and Miscellaneous Provisions Act 1955. 2. Whether Sri J.N. Pradhan was in regular employment under the opposite party management with effect from 14/2/1962. If so, whether he is entitled to get any amount as applied under section 17(1) of the above act in prescribed application, copy enclosed. 3. Whether the management's action in superannuating Sri J.N. Pradhan on attaining the age of 58 years on 6/6/87 is justified. If not, what benefits he is entitled?
Mr. Mishra, you're for the respondent.
I'm for the workman, Your Lordship.
Oh, you're for the workman.
Yes, yes,
Okay.
yes. I'm
All
for
right,
the-
all right. Usually, you're just the management is wondering.
Just a change.
Yes.
Actually,
yes.
the deceased workman was a very good friend of mine. So
I
after
see.
his death,
I
I have
see.
taken over the legal heirs.
All
Your
right.
Lordship, I want to just pray for one thing. Has the
Yes.
LCR come, Your Lordship, in this case? Because reference will have to be made to the LCR, Your Lordship.
Okay.
I don't know.
No, apparently it hasn't. All right.
Matters.
All right. The lower court record we requisition forthwith, since Mr. Mishra and senior counsel for the
Petitioner
states that reference will have to be made to it. List on 1st May. 1st May.
Your Lordship.
No, sorry. We'll have it on 8th May. Sir.
8th
No,
May.
sorry. 9th May. Sorry.
All right, Your Lordship. Yeah. It's all right. 9th. Grateful, Your Lordship.
Right. Item number 3.
Regular list.
Item number 3.
My lord, I'm for the opposite party, my lord, respondent. Before my senior starts, may I submit a few lines that the appeal memo is filed only along with the SESTAT order and other assessment order, actually 2 assessment orders, 2 commissioner appeal orders, and 1 assessment, 1 SESTAT order is to be attached. And also, this is only a partly allowed appeal on Indian diesel inside the seat.
No, we don't know, but monetary effect itself may be less, sir.
Yes, my lord, exactly. So it is 15 lakhs. It is 15 lakhs, and that amount is not mentioned because partly allowed appeal. If they verify and cross check that, this will come under 15 lakhs, my lord.
No, it's 24,
No, it is
27 lakhs.
No, it is not.
27 lakh, 57,000.
No, but only partly allowed, he says.
Yes,
No,
partly allowed, my lord. It is partly allowed. 27 is not the entire amount on the Indian origin fuel inside the bunker. It is the pay is, my lord, 20.
Appeal is allowed to the extent of demand of duty on ship stores of Indian origin.
Only.
Yes.
It is not 20 lakhs.
So what is the extent of that demand of duty on the other?
That I have to see whether the demand is 27 lakhs.
Yeah, you say
demand is entire 27 lakhs, but partly is allowed.
States that he will examine whether the tax effect as a result of the impugned order of the SESTAT is below the monetary limit.
My lord, further I pray that this should attach the other assessment order.
Paragraph. The complete paper book is served on counsel for the respondent before the next date. List in the regular list on 8th May. Sorry, on 9th May. Sorry, 9th May. Right.
Item number 4.
May I please, Your Lordship? So in this case, the petition is ASL input order annexed 7, page 36. This is OPL matter. Petitioner 1 and the father petitioners 2 to 5, they are landless person, and the encroachment case was initiated against their name. And the land, since the landless person, land is settled by the annexes 3, page 18. And after expiry 8 years, the land is cancelled by the annexes 7 on the ground that petitioners are not the landless person below. My submission that annexes 3 after
No, but 1 minute. This annexure 7 you're challenging.
Yes, Miller. So
This
in
is the appeal by the opposite party.
Tahsildar to Tahsildars. Sub-collector and Tahsildar.
No. That annexure 7.
Yes.
Your appeal has been allowed.
No, Miller. State preferred appeal.
State preferred.
Tahsildar was the appellant.
Tahsildar appellant.
Oh.
So after expiry of 8 years, the land has been cancelled by the sub-collector as per the appeal preferred by the Tahsildar. My submission that in the event of what the father of the petitioner 2 to 5 died in 2008, appeal has been preferred in 2012. And the legal heir of the father, the legal heir of the lessee has not substituted before the appellate authority prior to cancellation. Miller. And Lordship kindly see.
No, but do you have documents to show that
He should have filed revision against the appellate order because this order is revisable. Collector is the revisional authority.
Oh, I see.
Let him file revision.
All right. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to challenge the impugned order dated 8th October 2012 of the additional sub-collector Jaipur by way of a revision petition before the collector. Jajpur, is it? Sorry.
My lord, in fact, in some districts, the collectors have assigned the ADM to hear the revisions.
Oh.
Revisional authority.
You say before the revisional authority, right? Paragraph. If such revision petition is filed not later than 1st March 2023, accompanied by an application for contestation of delay, explain the delay on account of the pendency of the present petition, then it will be considered in accordance with law by the revisional authority. The court clarifies it is not expressed any view in the matter. If the revision petition is filed within the aforementioned time, then till its disposal, the interim order passed with this court on 30th May 2000. No, then till its till the disposal of the said revision petition, no coercive steps shall be taken against the petitioner.
Certified
copies be returned, subject to being substituted by attested photocopies. The writ petition is disposed of the above terms.
Item number 5.
My pleasure. My lord, I have prepared a small date chart for convenience. Yes. May kindly see. 5-6 dates will be relevant. My lord, way back on 1/10/2008, 1st of October 2008, a notification was issued for acquiring the land. But the purpose was construction of the Chandbali road. But in Annexure 1 and 2, they sought for acquisition of 4 decimals and 2 decimals out of the total extent of 2 decimals out of 8 decimals and 4 decimals out of 16 decimals. But now, suddenly after at the stage of Gujarat, they said that the whole land is acquired. At that stage, I came to this Honorable Court. And this Honorable Court specifically passed an interim order that those lands which has not been notified to be acquired, that no course of action shall be taken and no possession shall be delivered. Now, during the course of hearing, on 22nd of December 2015, you will see passed the order directing the state government to produce the Section 4 notification, Section 6 notification, and Section 11 order passed thereon in the in case matter. That you will find at page 29. For a movement, if you also kindly see, the 4-1 notification is of 24th October 2008 and Section 6 declaration was 31st/12/2009. My submission is it is beyond 1 year. So direct application of provider to Section 6, it lapses. Even then, another aspect.
No, but you can't challenge it in 2014, sir. Clearly barred by latches.
Yes, 2014 they issued a notice saying that whole land is acquired and that to crop insurance compensation is to be paid to me for the whole land. That challenge, you said you intended to acquire 6 decimals out of the whole area. Now at the stage of Gujarat, how can you say the change and turn around and say that whole land is acquired? And my small tiffin shop is running there in my land. So on the one aspect, Section 6 provides you the proceeding lapses. Another fact also, the Section 11A provides also the award, they say in 2016, pursuant to the order, the affidavit they filed, that says 2016. Even then the lapses. And in the meantime, the new act has come on 2013 act. So on 3 counts, the proceeding lapses. If at all, now the present position is the land which they constructed the highway, that has been deviated from my land, and they do, perhaps, I do not know, the government can say they may not require my land.
Let me take instructions.
All right. Counsel for the petitioner inter alia contends that the highway in question now does not pass through the land in his possession, and therefore the government may not require the land anymore. Paragraph. Counsel for the petitioner, for the state, seeks time for instructions.
But if they have processed for denotification or de-reserving the land, then
and a supplementary affidavit be filed by the state on the above aspect and any further developments that have been take place before the next date, included in the regular list on 9th August.
But interim order is there, that may kindly continue.
Or interim order.
Deep localized.
Item number 6.
Pardon, my lord. On the item number 6, my lord, there is a. May I submit, my lord? On item number 6, the notice is showing that the opposite party number 3, 4, 5, 3, 4, and 5 has filed the counter affidavit. And I am appearing on behalf of Mr. Dayananda Mahapatra for the Cuttack Development Authority, the opposite party number 6. The counter copy is not served yet, my lord.
No, what's the prayer in your petition, sir?
My lord, Mr. Damdar Pati was appearing on behalf of the petitioner. He expired. I have instruction to appear, my lord. Your lordship give some time.
No, counter is already been filed. Let's just see this 1 minute. Counter is already filed. So whom are you appearing for?
Counter copy also not served.
No.
My lord,
my lord, on the item number 6.
Yes, whom are you appearing? Development Authority.
Cuttack Development Authority.
You should say that. You see the counter affidavits of opposite parties 3, 4, and 5, and opposite party number 7 be served on Dr. Lanka, who states he is now appearing for the petitioner. Paragraph, counsel appearing for the Cuttack Development Authority needs more time to file a reply. Stop the reply if any of the CDA be filed within 4 weeks. Rejoined to all the counter affidavits be filed for the next date. Interim order to continue. List on 16th August.
Item number 7.
In the regular list.
Item 7.
May I please?
My lord, kindly peruse the last order sheet, order dated 15/9/2022.
All right. The perusal of the order dated 15 September 2022 reveals that the matter is part heard before the bench of S. Talapatra Jain and MS Sahu Jain. List before that bench. On 6th February 2023.
Item number 8.
Obliged.
Much obliged. Item number 8.
No, please.
Item number 9.
Same order.
Item number 10.
If cause of actions further survives, then I will file the application. Well, to file no instruction from the
withdraw the present petition.
no instruction from.
Since he has no instructions. Sorry.
Item number 11.
Lord, item 11, I am on VC. Lordship may kindly permit me to appear through VC.
Yes.
Because I am indisposed of today, my lord.
Then we can take it some other days, sir. Not to worry.
Lord, it's similar order to be passed only, Lord. I have given you a set of orders to your Lordship. Lordship has remanded the matter back to ASO because no notice was given. I have suggested little corrections.
All right. Same order.
Grateful.
All right.
Item number 12.
I am for the opposite party.
None appeals to the petitioner. Dismissal not possible. Interim order. I don't think so. There's probably not any more. Right.
Item 13.
Your Lordship, I am appearing for opposite parties 1 and 2, ITCO.
Lord, I am appearing on behalf of Mr. P.K. Behera.
For whom, sir?
Petitioner. Petitioner, madam.
Yes.
My lord, no instructions.
Dismissed for no. Counsel, the petitioner states he has no instructions. Dismissed. Note down her name for ITCO. Right.
Item number 14.
None appears dismissed.
Item number 15.
My lords, my lunch and DK Pradhan is ill. Kindly take up this matter tomorrow, my lords.
All right, stay on board.
Item number 16. Item number 16.
None of it is dismissed.
Item number 17.
None of it is dismissed.
Item number 18. 18 on behalf of Mr. Abhay Kumar Parada, I place my lord. The annexure 16, a pending before the OP number 3, my lord. The matter related to non-transfer of tenements constructed under integrated subsidized housing scheme for the industrial workers and economically weaker section of the community. Annexure 16 is pending before OP number 3, my
File a
lord.
fresh representation.
My lord.
This is a 9-year-old representation, sir. You make a fresh representation. Permitting the petitioners to make a fresh representation to the authorities in accordance with law and after following up on such representation to seek appropriate remedies. The petition is disposed of.
That representation is still pending, my lord. Annexure 16.
But that nobody did would have got lost, sir.
My lord, my lord.
Make a fresh one.
My lord. In a stipulated period, that will be disposed of.
All right.
Item 19.
Please, Lordship. Here, my lord, petitioner has challenged the demand notice, which is issued by the opposite party against the defective meter, my lord. And the lower forum, non-ombudsman has set aside the demand notice and revised that bill. And the Lordship have come to running page 30, my lord. Basing on that, they have calculated and the amount was paid by the petitioner, my lord. So there is nothing to left except the DPS they have not calculated properly, my lord. Because DPS they have calculated delay payment surcharge basing on the earlier demand notice. So only thing is that if the DPS they have should be, because of their calculation, on the basis of their calculation, as per the direction of the law and ombudsman, petitioner they paid the amount, my lord.
Have they been served?
Only thing is left is the delay payment surcharge they have to be calculated.
This SESU is still there or they've all been taken over, sir? This electrical CESU, is it still there?
No, it is changed. It is a TPCODL.
Then?
TPCODL.
So do you have?
So I have to file a press application with regard to the TPCODL. Representation that will be as per the law they have to dispose of.
When will you do it?
Lordship will dispose of that petition, present petition I have to file because they have to be calculated the DPS along with the present.
The petitioner states that he will approach the Tata
Power Central Odisha Division Limited, TPCODL.
Tata Power Central Odisha Power Distribution Company Limited with a appropriate
presently the opposite but not true, my lord.
For recalculation of the what is DPS?
Delay payment surcharge, my lord.
Delay payment surcharge,
my lord.
And after following on such application to seek appropriate remedies in accordance with law, the petition is accordingly disposed of. The interim order is vacated.
Obliged.
Item number 20.
Please, your lordships, my lord. The petitioner claiming back wages, my lord, referred, my lord, item is case number 12 of 2014 before the, my lord, the London Labour Court, Jaipur, my lord. And that has been, my lord, others in case of others, my lord, that has been allowed. Annexure 3 series, your lordship may kindly have a look at page 15. Similarly situated persons have been allowed, but in case of mine, my lord, it's my misfortune that I was arguing the case myself, my lord, the employee. So, my lord, this is, my lord, it has been, because no documents have been brought on record with regard to suspension, my lord, the court has taken exception and it has dismissed my case, my lord. But the fact remains, my lord, since 81, I was working, my lord, as a supervisor. And till 2000, I was getting the salary, my lord. Thereafter, my lord, from 2000 November, we were not paid salary, my lord. And because I protested, I was put under suspension in 2004, my lord, after 4 years. And my lord, ultimately the society went into liquidation, and this annexure 2, your lordship may kindly say, annexure 2, page 10 was passed, my lord. And my lord, in that, my lord, this document was there before the.
See, you're already 60 years in 2015.
My lord. Only back wages, I am claiming back wages, my lord. Lord, everything is gone, my lord, only back wages from 2004 to, because others have been benefited, your lordship may kindly say, annexure page 3, page 15, annexure 3 series, my lord. Same labor court, same labor court has allowed. But in case of mine, my lord, because I was, and your lordship knows, my lord.
But without documents, how can you be?
That was, my lord, the matter may be remanded back so that I'll place all my records, my lord.
All right, that appears for opposite party number 1. Despite service of notice, paragraph, the challenge in the present petition is to an award dated, is an order dated 22nd August 2014, passed by the Labor Code Jaipur, industrial dispute, miss case number 12 of 2014 under section 30 capital C bracket 2 of the Industrial Disputes Act 1947. Bracket Act. The appellant, who even at the time the impugn award had been passed, had superannuated, was claiming a sum of ₹3. What is it? Sums even that is not clear.
No, I have mentioned in that matter, but the lower court has not gone into those aspects, accepting that.
No, what's the amount?
My amount, that petition I have not filed because that was not available with me. But it was there and it has not been quantified.
No. The impugn order typographical error is there. This is some 3 lakh something.
Madam. Yes, madam. In the third line, madam.
What's the correct amount?
No touch with the client, madam.
Why are you wasting time, sir? If you're not in touch with the client, then what's the point?
No, your lordship, kindly remind.
He will not even appear in the labor court if he remanded. What's the point? Don't simply argue like this if you don't have even instructions from your client.
Your lordship, kindly.
What's the point?
Give one chance, my lord. One chance.
Chance for what? Is he there? You don't even know that you've not spoken to your client.
But I was contacting him, my lord, in the number.
Then what is the point? You don't even know. You don't have instructions and you're simply arguing before the court. And we no, and just say you have no instructions. Say you have no instructions, you be done with it.
The lordship, one chance, man.
Chance for what, sir?
So that you will produce all the documents, man. If it is alive.
No. First find out that. If you don't, you're not able to find out that. What's the point? Why are we
Let me give a try, my lord. Your lordship, keep it to Wednesday or Thursday, my lord.
Or it will stay on board.
Matter. Lordship, kindly take it up on Thursday, my lord.
Item 21. Item number 21.
None appears dismissed.
Item number 22.
On behalf of Pickera, one advocate, no instruction.
No instructions dismissed.
Item 23.
And here I am for the opposite party bank. In between account has been settled and closed.
None appears to the petitioner. Counsel of the bank states that the matter has been rendered infructuous. Dismissed.
Item 24.
None appears dismissed.
Item number 25.
Madam, this matter was previously assigned to single bench. That's why the single application has been filed and notice was issued. I am filing the second count today.
What's the matter? What you are for the petitioner?
Madam.
What is it about?
There is rejection of no settlement granted by the commissioner. The order. Endowment commissioner under 19A of the.
You can renew it, sir. Now, many years have passed. You can apply afresh for another no objection.
No, my land is to be alienated under the permission of the commissioner. Otherwise, not. That's why my difficulty. I am filing the second copy so that.
No, we have enough copies. Now it's all paperless, sir. No problem. Tell us what the matter is about.
Well, the original the land was recorded the original because it is Bhagavad Gosai. Man, there is no idol, but the collection of palm leaves. It is inside the house of the original owner. And he sold the land to a third person, that is the Muslim community. And he sold it to the petitioner. And now when the petitioner is wanted to sell that, the permission is required under 19 no objection certificate.
When did you last speak to your client?
Madam?
When did you last speak to your client?
Last week I have got talks with my client.
How old is he now? How old is he now?
Seven years in 15. 71 years and 15. 80 or 82.
Your arithmetic is worse than mine, sir.
I have talked to you, but no.
85 plus.
85 plus. May I pray, my lord? Let it come next week. I will contact you.
Please contact your client.
Yes, next week.
It will be on board.
Stay on board.
Where?
After lunch. We come back.
I will not tomorrow. I will absent tomorrow.
item number 57.
May I please, Lordship? Lordship, I am in virtual mode, Lordship.
All right.
This is a case, Lordship, where this honorable court has directed to the government to formulate the policy. Lordship, government has taken twice time.
Let them first speak, sir. Let them first speak.
My lord, on behalf of the collector Puri, one affidavit has been filed before your lordship on that is there on 11th January 2023. Lordship. The important document is, it is there, my lord. Page 7. Page 7. Page 7. This is the letter of the collector to Tahsildar.
Application. What's the application number?
This is the main writ petition.
It's an affidavit.
Yes, an affidavit has been filed by the collector Puri.
To 2610 order.
That is dated, the affidavit is dated, yes, ma'am, 11th January 2023. That hard copy is with me. Achi?
You have a copy?
I have a copy.
No, let him.
I have soft copy. Another copy I'm just nice.
Well, it's passing another one.
Page 7. That is the letter of the collector to Tahsildar Brahmagiri and Kushna Prasad. Next page is important. In this connection, it may be mentioned here that the Government of Revenue and Disaster Management Department, Odisha Bhubaneswar, have been pleased to pass order for using the drone technology by hiring the drone. The hiring charges of the drones will be made out of the fund earmarked for protection of government land. I would therefore request you to please survey the illegal gheris by using the drone technology, by hiring the drone in your respective areas, minimum twice in a week, to ascertain the actual illegal prawn gheris under your jurisdiction, so that an early action will be taken to demolish the said illegal gheris for compliance the order on the Honorable Court. So we have started this technology by drone camera. We will observe that whether there is any re-emergence or there is any illegal gheri anywhere, and we will take immediate action on it. And twice a week, the government has directed to make a survey of all these things. So there is a surveillance under the drone camera, and that is in pursuance of the directions of this Honorable Court.
And now the district administration had supplied a small trial run video of this drone. If your lordship's permission, it can it be played? It will be helpful to assess kind. It is very useful, the manner in which it will take place. So your lordship may see, these are earthen embankments constructed within the lake, which have to be demolished, and these are huge.
My goodness.
And through this method, very effective patrolling can take place, and your lordship can see too much of earthen embankments. The district administration, we had a discussion that some sophisticated machinery needs to be employed with the help of CDA, so that this thing can take place.
This left corner is all embankment, is it?
All yes, your lordship. Just adjacent to the lake, and inside the lake also they have constructed many. So the natural lake has been destroyed completely.
Right. Right.
So this is taken from the drone camera of the government.
Of the government.
But Lordship, this embankments, Lordship, this is the pursuant to decision of the state government in 2 occasions. Once the state government taken a decision to hand over the Chilka to Tata, Lordship. So that's why they have created these small ponds. And another, Lordship, they have handed over to Omkar Corporation for palm plantation. And others are, Lordship, they are some are to protect from floods and these embankments are.
Floods and all, please.
No, I'm not.
Different thing altogether.
No, I'm not, Lordship.
Floods will be the edge, not in the middle of the lake.
No, Lordship. I'm saying the ground. Lordship, the decision by the state government, this embankments are created by Tata. And Lordship, some of them, Lordship, by the government itself. So I am not saying to protect this embankment, Lordship, but at the same time, Lordship, can I remember if there is.
These square ones, these are all prawn culture farms.
No, these are created by Tata, Lordship.
These square farms.
These are Tata and Lordship. Lordship, kindly remember that Benami culture. These are the outcome of that Benami culture. Lord. They are entertaining Benami culture in Chilka. These prawns are, Lordship, the sophisticated prawns, Lord, that is Benami culture.
That is at the beach area of Chilka Lake. That is not at the mid of the Chilka Lake, Lord. The information submitted by the state is a right commission, Lordship.
1 minute.
Lordship.
Oh. भीतर से ले आ रहा हूँ sophisticated ones को नहीं दे रहा Benami culture এটা চিলিকা ভিতর নোয়া চিলিকা টাটাকে দিয়ে দিলেন না চিলিকা Benami culture কি করলে গভর্নমেন্ট ডিসিশন ইলিগাল Benami का इशू वर्जन Benami culture से पूरा एग्रीकल्चर लैंड लगी ची ऑल आर Benami लेक को लगी ची all the sophisticated ponds, Lordship, that is Benami culture, Lordship.
All of this is Puri.
Krishna
Prasad.
Just one tehsil.
This is only a part of.
So if we go further down and up, again we will find many Kendrapada and Ganjam and all.
No, in fact, Chilika is, Lordship, more especially in Krishna Prasad Block, Lordship. The feasible sources all are available in Krishna Prasad Block. Almost 90% of Chilika available there, Lordship.
All right. What is the other video?
Lordship, with your Lordship's permission.
No, not yet, sir. No permission yet. Wait.
This was only one video, Your Lordship. Now, this is in Ganjam. This is a different thing. These are the net gheris which have come up in Ganjam, which have supplied.
Keep going.
This much, Your Lordship.
This is you have taken it, is it?
This I have personally. The local villagers have sent me.
This is as recent as 31st December.
Yes, Your Lordship.
Oh,
this is of Ganjam.
Okay.
I have supplied it to the collector also, but he has not taken any action.
No, third one. There's one more, sir.
Any more?
No. 3 pictures. Only 3.
Another picture there is, I think. No, close this. Close this. 1 minute. Both those WhatsApp, all 3 images you've shown. All right. Yes, Mr. Biswal.
Lordship, this is a case. The earthen carriages are meant to check the flood in the local areas.
No. Not in the middle of the lake. You can't have all this for checking flood.
State, Lordship. On the expenses of the higher irrigation department, all these earthen carriages are there to check the high flood, but not the water. Chilka water should not be entered into the village area, Lordship. If, Lordship, all these earthen carriages will be evicted, the action will be taken to evict all these earthen carriages, Lordship. Government of Orissa Treasury will be adjusted, Lordship. What is required the day order of the day, Lordship? Your Lordship need wetland management, side aside people's life, bread and water, Lordship. On that issue, Lordship, what is required? The community involvement, participation of the people across Chilka. It is not only the CDA or the revenue department or the fisheries department will solve this problem. Unless the community involvement is there, Lordship, all these situations what is arising out of in the present day scenario, that cannot be solved, Lordship.
Mr. Biswal, in the name of community involvement, we can't have anarchy. All right. Some 10 people will want it to remain. 10 people will say, no, it should go. There will be total anarchy if you simply say community involvement. There are several communities and all working at cross purposes.
Lordship,
you have to be careful when you make these kind of submissions.
Lordship,
all communities there do not think alike. All communities do not have commonality of interest. There are communities working at cross purposes. You yourself know that. So don't simply say community involvement.
Lordship, your Lordship have a glance to the order dated 4th May 2022, Lordship, order number 66. Just have a glance. Your Lordship,
yes, we'll have that. We'll first hear the collector Puri, what he wishes to do on this. What is your plan, sir, Mr. Verma?
Good afternoon, sir. As per your kind direction, sir, during the month, the drone shots that you saw were taken during the month of November, sir.
Right.
After the order, sir. So it was a trial run, sir. And as you could see, sir, there is extensive prevalence of earthen gheris, sir.
Correct.
Net gheris we have been able to successfully minimize, sir.
Right.
Water body, sir.
Right.
But this earthen ghery demolition requires huge amount of manpower, sir.
Right.
What we do currently, our modus operandi is, sir,
yes,
we take a few laborers and we demolish around 50 to 100 meters of the embankment, sir, and then file an FIR, sir. So cumulatively, we have filed almost 115 FIRs, sir.
Right.
And as in the month of January, we filed 3 FIRs, sir.
Right.
If we want to totally make it non-remunerative for these people, sir,
right,
we need massive machines like dredgers, etc., sir, which can demolish the embankments in a way that they do not get reconstructed immediately, sir.
Exactly.
They have a punitive economic cost to the reconstruction of the embankment, sir. So
correct.
Would be to because with the limited resources we have, sir.
No. See, when you launch on a task like this, you'll have to tell us what is the extent of your task and in what manner are you going to go about achieving it. So let's say there are so many land embankments or land earthen gheris. You tell us what is the extent. You have an approximation of the length of such earthen gheris with its 5 kilometers, 10 kilometers, whatever.
Sir.
And how much can you achieve on a daily basis and how long it will take? What are the resources you need? Only then you can have planning.
Sir, we have basic data on the prevalence of the earthen gheris, sir, in terms of area, sir.
What is that?
Almost 10,000 10,000 hectares, sir, both in Brahmagiri and Krishna Prasad blocks. Sir.
No, that's the total extent of the encircled area. I'm talking of the actual earthen, embankment, which you need to remove.
Sir, the perimeter we will have to work out, sir.
Do that. So that is the real work. Removing that earthen perimeter is what your work is.
Yes, sir. So my point was, sir, even if we remove it, sir, it is very easy to reconstruct it, sir.
No, that's why you have the drone surveillance, sir.
Sir.
That doesn't mean you don't start doing it. Merely because there's a possibility of it coming back, you don't say, I'll give up right now and not do it at all.
No, that was not what I meant, sir. We continuously have drives to remove that, sir. And also take action in terms of FIRs, etc., sir. But the extent of prevalence is huge, sir. So if we want some real output in a very short period of time, sir, we need...
No. Don't mistake me now as saying we want output in a very short period. We want you to start the work. We want to be realistic in the targets that we fix. We don't want to fix unrealistic targets for you, which is what we want you to tell us. What is the extent of work involved? How much manpower you need? Then we can issue directions for that.
So, for example, sir, in the month of December and January, sir, we have demolished 577 hectares of earthen gheris, sir. So,
no, that is a bit misleading. You see, let's say 2 hectares is surrounded by an earthen wall of, let's say, 500 meters. You would have actually effectively destroyed 2 earthen walls, but what you would have recovered is several hectares.
Yes, sir.
So merely telling us how many hectares has been recovered will not give us the correct picture.
Right, understood.
Hmm.
So, sir, we will rework it and put it in terms of meters of embankment which has been demolished.
And how long it is taking you? Suppose it's taken you to remove 500 meters of earthen embankment. It takes you, I don't know, I'm just trying to think, 2 days or 3 days.
Sir, if it is accessible by a JCB machine, sir, so as you could see in the drone footage, sir, every embankment is not accessible by a JCB machine, sir. Many areas which require manual people to go through the.
No. So at the places at which you will cause the breach, that itself will serve the purpose. You see, the point is, you may begin by causing breaches on those earthen walls at strategic points so that there is no pond formed. Ultimately, for a shrimp farm, you need an encircled thing, right? Don't allow encircling of space by earthen gheries. I think your first attempt should be that, sir.
Yes, sir. We do that only, sir. We place the embankments in a way that water is drained out, sir.
So what will it take you to cause those breaches on those earthen embankments is what you have to tell us.
We will prepare a detailed estimate, sir.
And how far is this true that if you remove all the earthen embankments, there'll be huge flooding? Is that true?
Sir,
because I don't see how removal of earthen embankments in the middle of the lake can cause any flooding.
Lordship, with due respect,
Mr. Biswal, please don't talk out of turn. I'm now asking the collector something. If you go on interrupting like this, we will just have to permanently mute you, Mr. Biswal. Yes.
It depends on the flow of the water, sir. So maybe if there is a gradient, it might, and if there is not a gradient for the natural course of water which the embankment is obstructing, sir. So we need to have a study about it, sir, whether it causes or protects flooding, sir.
But it can't be that this extent of earthen ridges were created only for flooding. That makes no sense. I've understood at the edge of a lake for earthen embankments to be there to prevent flooding, not middle of the lake. I've never heard of that. My knowledge may be rudimentary and ill-informed, but I've not heard of middle of the lake earthen embankments being erected for preventing flooding. No, please give us an idea. Therefore, how long will you give us a plan, proper plan? Meanwhile, you continue, of course, the task of removal of earthen embankments. But give us a realistic estimate of how long it will take. Maybe you file an affidavit within 2 weeks or 3 weeks or whatever time you want for that.
Sir, we need to work with CDA on this, sir.
Right.
As a team, sir. That is number one, sir.
Right.
And we need mechanized ways to do it more quickly, sir.
Right.
So we need to work out on the kinds of machines that are required which can bypass embankments and reach other.
There must be also a visible change on the ground.
Right, sir.
The full network of those squares that we saw, if they're all illegal farms, then that should go immediately.
Right now, sir, in the month of January, sir, water has already receded back from many of these areas.
So this is probably the best time to do it then.
That is true, sir.
So we will flatten it out. This is the best time to flatten out the whole thing.
Sir. Right, sir. So CDA.
So you accelerate your efforts this month, put in more whatever ACBs or whatever you have to do and get it done.
Right, sir. We will work with CDA, sir, and we will figure out.
No, but give us some time estimate.
Sir, already we are doing a lot of work, sir, as has been filed in the affidavit, sir. So, but this exact meters of embankment rather than the area which we have demolished, sir, we will expedite it, sir.
And have a drone taken almost every day and have a file. You have a folder in your own whatever office, electronic folder. Every day have a drone capture. Every day. And if you so desire, you can have it 3 times in a day so that you can actually monitor what is happening.
Sure.
It should be possible to do that. I don't think there'll be any difficulty.
Sir, only cost is a concern.
Whatever it is, sir, this is a task which is long overdue.
Yes.
And this is going to help you in a big way.
Sir.
All your apprehension about re-emergence, all that can be taken care of if you have 3 times of the day when you have the drone capture.
Sir, right, sir. So we will do it.
But what about the collectors? Are the other two collectors here? Three collectors? Ganjam, Kendrapada and
Kendrapada
Khurda?
collector must be there.
Collector Kendrapada is
Yes,
there. I just saw
collector
him.
Kendrapada is there.
Yes, sir. Collector Kendrapada.
Good afternoon, sir.
Good afternoon.
Sir, government has also approved the using of drone technology for our district, sir. We have also given purchase order for the drones for 2-3 tehsils, sir. By 25th, we'll be getting drones. Sir, we have also made DP-wise detailed plan so that we'll have the pictures and photographs of all the Gram Panchayats first, just to detect how many emergence or re-emergence have been there, sir.
Right.
Then sir, within 2 weeks, sir, we can make an assessment how many men and material will be required, sir, for demolition. Because
right.
As Collector Puri has told, and as we have seen from the drone technology, sir, this re-emergence and recreation of Ardhangiri is not a difficult task, sir. Even if you demolish from 2-3 sites, they take hardly 1 day to reconstruct it. And regular surveillance will only help us in demolishing them, sir. So by 31st of January, we'll get the pictures of all the GPs, sir, and we'll update you, sir, regarding the demolition plan, sir. And the good point is, sir, January to June, we don't have monsoon, sir.
Correct. This is the best time to do all of that, sir.
Yes, sir. So most of the places are actually accessible, barring few places maybe. So in 4 or 5 months, we can intensify our efforts, sir, and ensure demolition, sir.
All right.
Sir, we'll update about the photos with photo affidavits and also the requirement and action plans.
Sir, you're following up on all those criminal cases that you've registered, correct?
Yes, sir. We have been following up, sir.
Right. Because we should take it to the logical end. I don't know. I think through you, we also request the state government. These mere filing of FIRs is not enough, sir.
No, they are forwarded.
Filing charge sheets, taking it to trial, getting some convictions, all that is important.
Yes.
Otherwise, again, the same wrong message will go out that FIRs will get filed and nothing will happen.
No, they are immediately arrested and they are forwarded. And
no, even arrest, sir. They'll probably come out and bail in a
same days, almost.
Either they have 1 week maximum.
They are also getting anticipated balloons.
End of the trial.
Exactly.
High Court is giving, what can we do? Honorable Court is giving advance bail to some of them. So
that is not the end of the matter.
Yes, charge sheet, trial, those things have to be correct properly.
Trial has to be completed.
Right.
So bail is not the end.
Yes.
They might have got, but follow-up action to complete the trial.
Yes, madam. We should ensure a logical end to all the criminal cases.
Otherwise, the deterrence doesn't happen, sir. Nobody is scared of the law.
Yes.
Nobody is scared of the law. That's the whole problem.
But Lordship permit me, then I can Lordship assist. So far the Puri is concerned. So far the Puri is concerned, Lordship Krishna Prasad Block. Collector made a statement to because of this Ardhan embankments, Lordship, it has come out earlier. In fact, Lordship, kindly remember, last occasion the state government has given affidavit. They have given 529 ponds permission for this Lordship Benami culture. In fact, these ponds, Lordship, the square size ponds and well dressed up ponds, all are Benami culture, Lordship. All has constructed inside Chilka. Lordship, kindly remember last occasion, Lordship put a question to the secretary, Lordship, regarding the revocation of the license. They had said, Lordship, because if it is an altered agricultural land or it has come up within the Chilka lake, it can be revoked. But this collector himself have given permission to more than 500 ponds for this Benami culture. And Lordship saw the entire square size and well dressed up ponds, all are Benami culture. So unless their license will be cancelled or revoked, they can come up with further Lordship demolition.
We'll ask him about that. Yes, Mr. Verma.
Permission is not given by the collector, sir. In my tenure, sir, we have not given any permission, sir. But I think in Chennai, that National Aquaculture Authority must have given permission, sir, way back, sir.
Long ago. Recommended. So I think we need to examine that also.
Right, sir.
Make sure that no fresh licenses are given and existing licenses are revoked.
We have not given any permission.
But you have recommended. No, but if you tell us the details of who's operating those, then we can issue directions on that.
We have the information.
What about the collector Khurda? And collector Ganjam?
Good afternoon, sir.
Good
Collector
afternoon. Yes, yes, sir.
Sir, we received information regarding some net-based gheris
Yes.
in Ganjam block, sir, bordering Krishna Prasad block, sir,
Right.
which is near Prayagi, sir. On 2nd of January, sir, we removed few of them, sir. And on 20th of this month, sir, we are going to completely remove all these gheris, sir, and action will be initiated against these fellows, sir.
So
We
every hearing, I think without us issuing directions, every hearing, we would like all of you to file affidavits updating the position.
Sir.
And every hearing from now on, give us the latest drone footage if your areas.
Your Lordship may give such a direction in the order.
That's right. Otherwise, every time we don't have to keep saying that.
That is better.
It's obvious because we need to know the latest position. So you saw those photographs that were shown. I think you were also watching it.
Yes, sir. Those net-based gheris, sir.
So what is the position today?
Sir, as of today, almost 30% of those gheris have been cut, sir. But on the other side, sir, there were some logistic issues. On 20th, we have issued notice, sir. Police, along with Executive Magistrate and Chilika Development Authority, sir, they will go and completely demolish those things.
All right. What about Khurda? Collector Khurda?
Khurda Collector. Sudarshan, Mr. Sudarshan. Oh, he's saying that it is coming invalid. I'm again sending the link.
All right.
But by the time your Lordship takes up these collectors' issues,
yes,
may I just have your Lordship permission to say a few things, my Lord?
Yes, yes.
My Lord, I have filed one IA flag 210. That's at flag 210, my Lord.
Yes.
These are all by the primary agricultural cooperative societies, my Lord, and they all survive by the, my Lord, capture sources.
Yes.
Now, your Lordship, my Lord, instead of burdening your Lordship to see and find out your Lordship's order, my Lord, as your Lordship has passed in IA number 18800, my Lord, your Lordship has specifically said in that para 9 of that order, may I just be permitted to place it, my Lord?
Yes.
It appears that although the applicant society is a registered society, it has no formal permission from the competent authority. Lordship, and can turn to page 21 of my IA. I have reproduced your Lordship's order, my Lord.
Yes.
It is also plain that after 18th of June 1999, no such permission is granted to any PFCS, including the applicants. Consequently, the question of permitting applicants to continue with its fishing activity doesn't arise. Considering plea of applicant society that earlier there was a policy by the state concerning the traditional non-fishermen, direction is issued to the Chilka Development Authority to examine the entire issue and submit its recommendation to the state government within a period of 3 months from the state government to consider whether any such policy needs to be formulated consistent with the judgments of the Supreme Court and the prevailing legal regime. It will open to the applicant society to make its submission representations to the CDA, which will give them a hearing on a mutually convenient date. Demarcation of areas in lake where such activity, if any, can be carried on doesn't therefore also arise in this stage. No further direction can be possibly given to at this stage on this issue. But this order, your Lordship, passed on the application of a society, my Lord, to give them opportunity of hearing. In fact, we are the persons, societies, my Lord, out of 200 some odd society, 11 societies are before your Lordship, those who are surviving on capture sources. Lord, their demands is that let them also involve in this process, my Lord, so that they can earn their livelihood, whatever comes out of that. But it's a stupendous work, my Lord. I am completely agreeing with your Lordship with regard to demolition of these gheris, my Lord. And all sorts of things I am agreeing with your Lordship, my Lord. But these capture sources, without causing any harm to the environment, as your Lordship has directed the society to be part of this process, these fishermen societies also be permitted to participate in the process, my Lord. That's what I'll be requiring and bringing for your Lordship.
This, who's for the CDA?
Chilka Development.
I have for the CDA, my Lord.
Yes.
My Lord, on 4/4, my Lord, and for submission that the Chilika Development Authority has already, my Lord, convened a meeting on 3/11/2022. You also kindly see IA number 16,578 of 2022. I have filed on 2/12/2022. Flag 212, my Lord. Flag 212. Your Lordship has directed the CDA as well as the Revenue Secretary to form a policy to cater the demands of the traditional fishermen and non-fishermen in the consultation with the Revenue Disaster Management Department of the Government of Odisha. As per the pursuant to that direction, my lord, your lordship kindly peruse that I internal page number I number 16,578 at flag 212 page 5.
Yeah, we have that.
That pursuant to that direction, the already a meeting was convened on 3/11/22, and these are the members. My lord, I am reading: Sushant Nanda, IFS Chief Executive CDA. Abhay Kumar Nayak, IS Special Secretary, Revenue and Disaster Management Department. Khushwant Singh, IFS Additional Chief Executive CDA. Basant Kumar Das, DADP Marine Department of Fisheries. Dr. R.N. Samal, Scientific Officer CDA. Dr. K.S. Bhatta, Consultant Fishery CDA.
So the next review meeting was supposed to be held on 4th week of December.
Yes, my lord.
Well, what happened?
On 3/11/2022.
Sir, on 4th week of December, what happened? You were to hold the next review meeting.
They have not taken it. The meeting is going on, but the next meeting is to be held on 19th
January. Are you meeting this? Are you hearing these fishermen societies?
That's right.
But pursuant to the direction of this honorable court, these are the persons in the committee. They are hearing. But your lordship direct.
We already directed, sir.
Yes.
We've already given you detailed directions. All this meeting is happening because of our direction.
Direction.
Yes.
So you read our directions. First of all, are you aware?
My lord.
Read our directions.
Let me correct Mr. Mahapatra. Your lordship never directed to formulate a policy. Your lordship directed to consider as to whether there is a requirement of forming a policy. Your lordship never directed to form a policy.
But I'm asking him to read the directions. You read the directions.
Right, right.
But they have to make a recommendation to the state government.
Let them involve the stakeholders and decide. That's all.
My lord, order dated 4/4/2022. My lord, paragraph 4. IR number 18,800/2021 is an intervention application by Ma Mangala Primary Fisheries Cooperative Society Limited, praying internally that they should be permitted to intervene in the matter by filing affidavits. IR number so-and-so is filed by the same society for a direction to the Puri district administration not to evict the petitioner society from the Chilika Sairat. The applicant society claims that after the order.
Don't read the whole thing, sir. Please read whatever is relevant for you, whatever directions have been given for you.
That's a paragraph 9. Paragraph 9. It appears that although the applicant society is a registered society, it has no formal permission from the competent authority to carry on any fishing activities. It is also plain that after 18th June 1999, no such permission has been granted to PCCF, including the applicants. Consequently, the question permitting the applicants to continue with this fishing activity does not arise. This is the considering the plea of this applicant society that earlier there was a policy by the state concerning the traditional non-fishermen. A direction is issued to the Chilika Development Authority (CDA) to examine the entire issue and submit the recommendation to the state government within a period of 3 months from the state government to consider whether any such policy needs to be reformulated, consistent with the judgments of the Supreme Court and prevailing legal regime.
So you don't have an endless time limit. What is the time limit given to you?
3 months.
Where have you now?
Pursuant to the direction, my lord, they have convened the meeting on first meeting on 3/11/2022.
So as it is 3 months gone.
My lord. Thereafter another meeting was held.
No wonder you say unless we direct, you will not finish this exercise.
There is a subsequent order also. Lordship may see order dated 15th September 2022 at paragraph 3. As regards the directions issued by this court to the Chilika Development Authority in the order dated 4th April 2022, that a policy should be formulated for traditional fishermen and non-fishermen, there is no response as yet filed by the CDA. It was suggested on behalf of some of the interveners applicants represented by Mr. Sukanta Kumar Dalai advocate that the Revenue Department should perhaps also be involved in the formulation of such policy.
Because
since this court, 1 minute, since this court was at that point of time, informed that it would be the CDA which would be best suited to examine the entire issue objectively and submit recommendations to the state government. These directions were issued. The ultimate object is to have a policy formulated to cater the demands of the traditional fishermen and non-traditional fishermen in the area. The court would like to reiterate the directions issued in para 9 of the order dated 4th April 22 and directs that In addition to the CDA, the state commerce. So there is a slight modification to the earlier order dated. That is what I beg to submit.
Because the state government has to take that decision, my lord. That is why this,
Unless you make a recommendation, sir.
the CDA has already requested the state government. And
No. Recommendation has to be made. That part of the order is unaltered.
You have to supposed to make a recommendation and you have to supposed to hear all these parties.
My lord, your lordship, I may be excused, my lord. This is the information I have received from the CDA, my lord.
No, but you when you make submissions in the court, you have to consult your client. You have to take proper instructions on what they're doing, and it can't be open-ended, sir.
My lord, further more time may be given so that I can instruct.
I think at every hearing we'll now ask CDA to remain present because this two-way thing is not working.
But lordship, one more submission, lordship, because I am also appearing for the fishermen community, lordship. But so far the policy is concerned, never fishermen has been restricted to catch fish, lordship, inside Chilka. Because
everybody is restricted. Don't say like everyone is restricted. No,
lordship.
Mr. Dharai, don't say
Lordship, please don't interrupt. Lordship, there is a policy in 94 policy. Fishermen are allotted only to capture fish, capture inside Chilka. That has never been prevented. Culture has been banned inside Chilka since 1997 as per coming up as Jagannath case Union of India. The Supreme Court gave a judgment 97. The entire culture has been banned. So fishermen community has never been restricted by any law from capture to capture inside Chilka. So at least the fishermen should not be restricted, lordship. That is
let them first come up with some policy document.
Policy. There is no policy at all.
Yes. Policy is there, but Mr. Rathpur have not gone through the policy.
Kindly see the order passed by my lords.
Perhaps you have not gone through the policy process of the state government. The policy still exists for fishermen.
Don't go beyond the orders. Honorable Court says that there is no policy. Kindly see the orders.
Yes. The DM Khurda is there now.
Yes.
Yes, sir.
So good afternoon, sir.
Good afternoon. What is your response, sir? Are you using drones? What are you doing since last hearing? What have you been doing?
Sir, regarding the demarcation part, sir.
Yes.
Sir, we have started the joint demarcation, sir, with the support of Revenue Department and CDA, sir. Along with them, sir, police also is doing the joint demarcation, sir.
No. Are you using drones?
Drone camera. What is the status?
Sir, we have not started the drone camera, sir.
You have to make that request, sir. We've already issued directions. The other 3 districts are already on the job. You'll have to do your bit so that there is coordination amongst all of you. See, the tendency is if you stop in one area, they will go to the next area. This is the tendency everywhere. So this entire stretch from south to north, one has to cover all of this. If they realize that there is very weak enforcement in one area, they will immediately start erecting the gheris there.
Sir, regarding the enforcement of gheris, sir, on regular basis, sir, almost on a weekly basis or once is doing the enforcement activity, sir. But we will also use a new technology, sir, the drone technology, sir, and we will do it, sir.
I don't know whether you heard what I suggested to the Collector Puri. You have drone capture videos on a daily basis at different times of the day and make a full library of that. Only then you will be able to monitor that same area, whether there's a re-emergence or not.
Sir, noted, sir. We will comply, sir.
And you formulate a policy of never destroying these video footages. You may need it even 1 year, 2 years later, sir.
Sir, noted, sir.
Lordship, at this point, may I be permitted to say something, Lordship?
Yes.
Lordship, so far as this Khordha district is concerned, absolutely in Khordha district, there is no prawn picture. Earlier, the collector...
Mr. Biswal, if we simply go by your certificates, nothing will happen on the ground. I suggest you don't get into this now. Let the collector Khordha give me a certificate. You don't have to give a certificate.
It is the collector's opinion. The earlier collector has said there is no prawn cultivation in Khordha district, Lordship.
All right. Let him say that, sir. You don't take upon yourself that huge responsibility. The collectors will do all that.
And your Lordship's order that is...
So, my lord, kindly see, my lord, your Lordship's order para 9. fourth
Yes.
line, from that
Yes.
fourth line, Mr. I don't have any adversarial issue with Mr. Dani. Kindly see, your lordship says, it is also plain that after 18th of June 99, no such permission has been granted to any PFCS, primary fishermen cooperative society, including the applicants. So everyone is having no permission. Your lordship has been pleased to note it. How can Mr. Dani make a submission contrary to your lordship's order?
No, I am making a submission based upon record. I am not making a fake submission. I am making a statement on record, which is in record. I have gone through judgments. I have gone through the verdicts of the Honorable Apex Court.
That's right, Mr.
I
Dani.
am not making a fake statement here.
All right.
So your lordship, only I request, kindly pass the order to CDA, involve us in the process. We are traditional fishermen.
All right.
And he is appearing for non-fishermen. He wants to obstruct us. That's the point.
My lord, that's why I told Mr. Biswal when he says community involvement, as it is there's a conflict between two fishermen cooperative
That
societies.
is everywhere.
And one more alarming thing is zero net is being used. It's quite alarming, my lord. It finishes the whole system in the Chilka. Whole system. Zero net finishes the entire system in the Chilka. There will be no sheet even available for the next generation.
Lordship, that is a wrong submission, Lordship. That is a wrong submission, but when I'm submitting that, there are certain species of fishes, those who cannot grow more than 1 centimeters. And that fish is to be consumed by the local fisher folk of the locality, Lordship. So the seed should not be available in Chilka. That is a wrong statement. That is a Lordship. Without any practical idea in Chilka Lake, Lordship.
All right. All right.
Pardon me, my lord.
Yes.
My lord, I am appearing for OP number 15, which is a non-fisherman society also, my lord. In addition to what my learned senior Mr. Raj said, I only request your lordship also involve me, direct for involvement of my society in the hearing before the CDA, my lord, Chilka Development Authority.
In fact, they should give us schedule of hearings. Nothing is happening.
Your lordship may direct for a schedule.
Next meeting is 19th.
All right.
Now, I think they have to prepare a list. Yes. There are number of fishermen society, traditional fishermen.
Lordship,
there will be an unending process.
In fact, Lordship, there are 2 occasions arose to frame the policy. Honorable Justice Hansera, Lordship, framed that policy while visiting the Chilka, Lordship. Surprisingly, he went there and visited enter Chilka, then he pronounced judgment.
Ask CDA to have the hearings there.
Lordship.
So there must be. Let the team of CDA go to those villages. You split yourself. How many people are there in your committee?
Yes.
How many are there? So you split yourself into subcommittees of 2 members each.
There are 10 members, my lord.
10 members. So have 5 subcommittees. Let them travel to all these villages and hear them there itself.
Yes.
And we request courts
don't invite them to
individual blocks where the.
That's right. Let them go there and hold a sitting there in those villages and hear the people.
Once
better.
CDA as well as the revenue and disaster management.
Whatever, sir. You form your subcommittees and do that.
Form the committee.
Yes.
Collector is to. Collector will.
I may be pardon your lordship. I have got a submission, my lord. Your lordship on.
Whom are you appearing for?
I some interveners, my lord. Our applications were pending. Your lordship had directed on 15/9/2022 at paragraph 13, my lord. Let me place your lordship's order. These applications have been filed by certain interveners who are represented by their counsel such and such. The cases are similar to such and such. They have applied for permission to the district level committee for undertaking shrimp culture and they are awaiting clearance of the Coastal Aquaculture Authority, Chennai's CAA. Although direction have been issued in paragraph 14 on 14th April 2022 that their case will be disposed of within a period of 4 weeks. These applicants state that they are not yet to hear from the CAA. According to them, though the DLC concern is given its approval, they are yet to hear from the CAA. The Secretary CAA shall remain present in virtual mode on the next date. This was a lot's direction. That was on.
That date was over, I think now.
No, he was also present on that day. But Secretary was.
Some glitch was there. Some glitch was there. Possibly it could not be taken up.
No. He was very much present.
He might be present.
Mr. Padi was present. Today he is also supposed to be remain present, Mr. Padi.
Mr. Padi is there, but sir, the
yes, my lord.
Coastal Aquaculture Authority representative is present today.
My lord, there is no direction. I don't think that.
All right. So next hearing, you make sure, sir, they're there.
Yes, my lord, my lord.
Because the direction we had issued on 15 September, what has happened to that? All the pending applications, have they been disposed of?
Accordingly, I have given the instruction, I wrote a letter to them.
No, Mr. Sarangi says his clients have not heard from the
No, not yet.
from the CA.
Paragraph 13 of that order, the lordship's order.
Correct.
My lord may read it the same in the same order. Next date you will be present before my lord and in virtual board.
All right. You just said today's hearing commenced with playing a video footage of a drone camera that has captured the extent of earthen embankments across the Chilika Lake with specific reference to the Krishna Prasad Tahsil. Full stop. The drone footages showed that there were earthen embankments running all across the water body. And the suggestion that these may have been erected to control floods belies credibility. Full stop. Clearly, as pointed out by the amicus curiae, many of these have been erected for the illegal activity of shrimp farming. Paragraph. Mr. Samat Verma, learned collector Puri, was present in virtual mode, explained that while the task of removal of these earthen embankments is ongoing, the systematic removal of all of them, while at the same time ensuring that they do not re-emerge, will be a considerable one, involving additional resources and manpower apart from machines. Full stop. He has undertaken to hold consultations with the Chilika Development Authority (CDA) and come up with a comprehensive plan before the next date of hearing on the extent of the earthen embankment that requires to be removed, the manner of doing it, and the resources that would be required. Full stop. Apart from placing these details by way of an affidavit, he will also indicate the possible timeline of achieving the complete removal of all such illegally erected earthen embankments. Full stop. The effect this might have, full stop. Paragraph 2 suggested to Mr. Verma that in the initial phase, the effort must be to ensure that there are breaches caused in the perimeters of such earthen embankment, so that there is no enclosed space within the lake which can facilitate illegal shrimp farming. Full stop. The impact that this is likely to have on the levels, water levels, and whether it could pose any risk to human habitation around the lake will also be examined and indicated in the affidavit. Paragraph. The collectors of the other three districts, namely Ganjam, Kendrapada, and Khurda, were also present online, and each of them has undertaken to deploy similar drone technology to have a proper survey conducted of the entire area within their jurisdictions, respective jurisdiction, and to undertake the task of removal of not only the net giris, but earthen embankments illegally erected for facilitating illegal shrimp farming. Full stop. The directions issued above to the collector Puri would equally apply to the collectors of Kendrapada, Ganjam and Khurda. Full stop. Paragraph, it has been suggested by the court that each of these collectors should maintain in their offices a library folder of drone footages taken on a daily basis at 3 different hours of the day. And for these footages to be preserved for a considerable length of time to aid effective monitoring and to ensure that there is no reemergence of the illegal prawn gheris that have been removed. Stop. The affidavits to be filed by each of them would report compliance with this direction. Paragraph. There is the court also considers necessary to issue a general direction that hereafter, prior to every hearing, an updated status report will be filed by each of the collectors of Puri, Khurda, Ganjam and Kendrapada regarding implementation of the court's directions. The court would also like to emphasize that the FIRs that have been registered with the removal of every illegally erected pond ghery must be properly investigated and these cases taken to their logical conclusion, which will include filing of charge sheets and conduct of the trial, ending in the result of the trial. Full stop. The court will be informed of the progress of the criminal cases on the next date of hearing in the affidavits to be filed by each of the collectors. Paragraph. The court takes note of the affidavit handed over today by the Collector Puri, giving an updated status of the action taken regarding removal of net gheris and earthen gheris and the cases filed as a result thereof. Paragraph. Then just say this directions to the Chilika Development Authority bracket CDA. In its order dated 4th April 2022, this court had in para 9 issued a set of directions to the Chilika develop to the CDA. Which bears repetition, just reproduce para 9. Stop. At the subsequent hearing on 15 September 2022, the above directions were reiterated as under reproduce paras 3, 4, and 5. Paragraph. Counsel appearing for the CDA drew attention to IA number 16578 of 2022 filed by CDA, in which it is entirely stated that an interdepartmental meeting was held by the CDA on 3rd November 2022. Full stop. While the affidavit states that the next review meeting was to be held in the 4th week of December 2022, counsel for the CDA informed the court that a further meeting is to be held on 19th January 2023. Full stop. There were 10 members present at the interdepartmental meeting held on 3rd November 2022. Stop. However, there's no indication in the said affidavit, in the said application, whether the specific directions issued by this court on 4th April 2022 and 15th September 2022 about hearing the traditional and non-traditional fishermen cooperative societies has been complied with. Full stop. Paragraph. Today, Mr. P.K. Rathal, learned counsel, appearing for one such cooperative society, which is the applicant in IA number 15769 of 2022, prayed that the said primary, the applicants therein, who are 11 primary fisher cooperative societies, bracket PFCS, should also be heard by the CDA. Paragraph. It is pointed out by Mr. D.K. Manthi, learned additional government advocate, that there are several such PFCSs who may want to be heard. Full stop. These could comprise both traditional and non-traditional fisher folk involved in either capture or culture fishery. Full stop. Their interests need not be in tandem and sometimes may be at cross purposes. Full stop. Nevertheless, they would have to be heard as part of the exercise of formulation of a policy, if at all, to deal with the concerns voiced by them. Full stop. Paragraph. The court therefore issues the following further directions in this regard. 1. The CDA will form subcommittees of 2 or 3 members to visit the various PFCS and hold sittings in the villages in and around the Chilika Lake as part of the exercise of implementation of this court's directions issued on 4th April and 15th September 2022. 2. The CDA will make comprehensive recommendations to the state government after completing the above exercise, not later than May 2023. Full stop. The state government will examine those recommendations and after due deliberations inform the court by way of an affidavit of this will be the fisheries department.
Fisheries department. Revenue and disaster management. Revenue and disaster management.
Secretary, Additional Chief Secretary.
Additional Chief Secretary.
Revenue and disaster management of the stand of the state government on the formulation of a policy. We'll stop. This affidavit positively be filed before the next date of hearing.
My Lord, Lordship may direct that before conducting the Grama Sabha or that meeting by CDA, they should inform the district administration so that we will provide policy, because there may be,
you say
that is very important.
The CDA will inform the local administration of the dates and possible venues of the meeting to enable the local administration to provide sufficient police protection for orderly conduct of such meetings.
Correct. That is required.
Full stop. The PFCS are requested to cooperate in the peaceful conduct of all such meetings. Full stop.
And can I request one thing to your lordship? That every fisherman society should be one representative, not that in a bulk manner.
They can indicate when CDA issues a notice, they can indicate.
Yes.
I believe that your lordships have been pleased to permit us to participate in the process, madam.
Yes.
But one of your representative, not
There
that
are 11 of you. I think you can have
there will
some
be
two people
chaos in the-
speaking on the behalf of 11 of you.
Quite correct, Lord. Quite fair enough. That will be fine, madam.
You say all the PFCS who wish to be heard by the CDA will furnish
subcommittee
to
of CDA, subcommittee of CDA.
who are interveners before this court will furnish to the counsel for the CDA such list on or before 1st February 2023.
Name of their representative.
Indicating the name of one or maximum two representatives who will be heard. Right.
Who will be heard.
Who will be heard. Correct.
On behalf of the PFCs.
Yes. On behalf of such PFCs.
May I have a request, my lord?
I take leave from your lordship, my lord.
Right.
My lord, is it required to file affidavit or the officer concerned will present will suffice the query of my court, my lord?
Sorry. What is that?
My lord, this aquaculture authority officials will.
No, I'm just coming to that. I'm just coming to that.
That is not.
I'm just
yet started.
Mr.
Okay,
Padi,
sorry, my lord.
being
Sorry,
present online.
I thought my lord is coming.
No, you're now such an expert. This being present online is not an effort at all, as you know. You're just switching on your camera and you're there.
Yes, sorry.
So similarly, request a CA officer to remain present online, apart from filing the affidavit. See, what happens is something said in the affidavit. If we have a question to ask, otherwise, again, we're wasting time. It's better to.
It is better, my lord. Definitely will appear and appraise.
Whoever files the affidavit will be present online. All right.
Yes.
My lord, I have filed 4 writ petitions. In one writ petition, counter result has already been filed. Other 3 counter affidavit have been filed, but copies have not been served. Yet the applications are pending with the Coastal Aquaculture Authority at Chennai.
No, that's what. Same direction, sir.
That
Some others also had
direction is
the
going
same
to
problem.
be given. That
And your lordship has given the interim protection to.
Yeah, that will all continue, sir. Whatever is there in the interim.
But I pray that these 4 writ petition may be here had separately, my lord.
No. That
because
is
on there, it is in respect of permission. Whether permission they will grant or not.
Today we are now issuing directions on that permission, sir. Because some others, like Mr. Sarangi's clients, also has not. They've not heard.
Dispose of our applications by the Coastal Aquaculture Authority, my lord.
Let the order be
stipulated period, my lord. Unless they are not this one, your lordship.
That's what we're just going to issue directions, sir.
Yes.
Then you say directions to the Coastal Aquaculture Authority, CA. You see in the order on passed on 15 September 2022, this court had issued directions to the Coastal Aquaculture Authority (CAA) regarding disposal of the applications pending with it for grant of permissions on the recommendation of various district level. What was that?
Level committee has already
District level committees. All right, that's what district level committees.
In all cases.
Full stop. The court reiterates those directions and further directs that
paragraph 13, my lord.
the CAA will dispose
Yes.
of all pending applications, if not already done, positively on or before 30th April 2023, and communicate its decisions to the respective DLCs, who will in turn communicate those decisions to the applicants, who are the interveners before this court.
My lord, interveners, and they have independently filed writ petitions.
Some of them have also filed independent writ petitions. The Secretary CAA will file an affidavit of compliance in this court before the next date and also remain virtually present.
The interim order may continue. My lord.
Interim orders in regard to such applicants passed earlier will continue till the next date.
My lord, CDA.
We'll have one before this side of the vacation.
CDA secretary may be directed to appear on the next date.
The chairperson CDA. Secretary CDA will also remain virtually present on the next date. As will the 4 collectors of Puri, Ganjam, Kendrapada.
Sorry, my lord, that is Chief Executive Officer, CEO.
CEO. Okay.
and Khurda.
Lordship, in my writ applications, the interim order may, Lordship, may continue.
All writ petitions, sir, wherever they're interim order. So we'll have it on 15th May, sir.
My lord, by 1st May, they will give the recommendation.
Correct.
So government will take a call on
weeks.
that. 1 month time may kindly be granted. 1 month.
Then we'll advance that by 15 days.
No, your lordship.
Because then we'll not give them till 1st May, we'll give it till 15th April.
1st June.
No. There's no hearing on 1st June.
Summer vacation.
Oh, before, yes, before summer. Yes,
Before
15th.
summer vacation.
15th June is fair enough. Yes. 15th May. I'm sorry. 15th. Before the vacation.
So will you complete it by, sir, by 15th April then? You complete it by 15th April. Don't say 1st May, not later than 15th April.
Yes, because
not later than 15th April. All right. So list on 15th May at 2 p.m.
Lordship, with due respect to my lords,
yes,
if we are interested really to protect the environment, there should be massive plantation of the across Chilka, Lordship, particularly the coconut trees that can save the environment. That is, it is avoiding to that.
All right.
The best way to check the environmental pollution across Chilka, Lordship. That's my and our Lordship. All these poor people against whom the case has been registered, they are only fearing. All these poor people, no action has been taken against all those big shots, Lordship. All these 4 cases which has been registered in Khurda district, Lordship, poor peoples have been entangled. They have no land, nothing. They are the laborers, and they are now running to the courts. Thank you, Lordship, for your Lordship. We have go through your Lordship's book, that Law, Property and Legal Aid to the Poor. Your Lordship, 2004 book, Lordship. If the poor people, those are farmers, those are giving food to us, they will.
Sir, Mr. Biswal, that's why lawyers are there like you. You should extend all possible help. But I can also tell you, you contact the Secretary, District Legal Services Authority in all the 4 districts. You give them the names of the persons who need lawyers. Mr. Biswal, I'm really telling you, if you think the DLSA secretaries have not taken action, you please inform me on the next date. All right.
As your Lordship, please.
All right. Okay.
Weekly list passed or matter item number 11. Item 11.
May I please, your Lordship?
You wanted to show some orders.
Lordship, small correction, let's count. Lordship directed only the stakeholder means only primary fishery corporate society.
No, I said
and traditional also.
Traditional and non-traditional, both have said.
Lordship. Sorry, Lordship. Non-traditional.
Impugned letter, the impugned order, that is 18/3/2014.
But all this survived now.
Yes. Only the question of refund is surviving. That additional amount which has been paid.
What is the amount?
That amount what we have paid, we have already paid under Annexure 7, the demanded amount.
How much?
The entire amount has been paid. That is also an admitted fact.
What is the amount, sir?
Exact amount, my lords.
Which item?
Lords, let me have a glance to Annexure 7, the demand. Annexure 7.
Amount is.
No, this is notice for recovery of dues. You want refund of the.
Refund of that. I have to approach the authorities, for which, your Lordship, there is a direction that you approach the authorities after quashing that letter, which has been quashed. Annexure 6 has been quashed. And the demand, with regard to demand, we have to approach the government. So a time to be fixed by the secretary to give us a hearing, and accordingly.
That is, I think, Excise Commissioner has been directed in that.
That case, in this case, Excise Commissioner, but he is sitting over the matter. He is not taking any decision. Actually,
No.
Money is
Can you
secretary.
say so? Every day your Lordship is giving direction to the Excise Commissioner.
But they have not yet passed orders.
It
in
is
this
more
case also.
viable to get, because in government level it is getting delayed, as the petitioners are in Excise Commissioner will get immediate order.
If my learned friend assures that, I have nothing.
No, I am not assuring. That is that order is also which you are relying upon. In that order, excise commissioner has been directed.
Excise commissioner has been directed, but that is why.
So you make an application then, if you not already made. Have you already made an application?
No, I have not made. It is your lordship directed, I will make.
Counsel the petitioner. You say the petitioner, let's take this off. You say the counsel of the petitioner states that the petitioner is still aggrieved by the non-refund of the amount deposited by the petitioner with the excise department. And for that purpose, the petitioner wishes to make an application to the excise commissioner. Without expressing any view on the merits of such claim, the court directs that if such an application is made to the excise commissioner, not later than 1st March 2023, then after hearing the petitioner, a reasoned order will be passed thereon by the excise commissioner within a period of 3 months. The order will be communicated to the petitioner within a week of it being passed. If agreed by such order, it will be open to the petitioner to seek appropriate remedies in accordance with you. The petition is disposed.
One clarification may be given that the annexure, impugned annexure has already been quashed in the subsequent earlier petitions.
It's all right, sir.
Annexure 6 has been quashed.
That anyway in your application, you will mention all that. Yes.
Obliged.
Item number 12.
Urgent copy.
Right.
12, 13, 14, it seems the counter has been filed, but counter copy has
No, but we were just asking you, you can file an appeal against
Before
this
the commission.
to the commissioner.
This is what has happened here, my lord. At that point of time, my lord, they were contemplating that e-auction that was challenged here, and that was ultimately was quashed, and it was upheld pending in the SLP. For that, my lord, for 2013-14, they did not give the license for the entire period. They first extended for 2 months, then extended for 3 months. Accordingly, they extended for the entire period, my lord. The MGQ, my lord, there is a shortfall of MGQ because of this, my lord. And they issued a letter that you can leave that shortfall as per Annexure 2, my lord. They withdrew this letter and they issued demand notice.
My lord, in similar matters, Mr. Lordship is directing the excise commissioner to examine if there is any status quo order that will continue.
Correct.
No, there's no interim order is not.
All right. So,
and one thing, my lord, the last item number 16, the petitioner has died. He has to be substituted by a legal heir, my lord.
All right.
That has to be, my lord.
In that case, your Lordship may direct that his successor
Legal heirs
will
will
file
make that
appeals.
You see, the petitioners in these petitions are permitted to file a representation to the excise commissioner for refund of the amount deposited not later than 1st March 2020, refund of the amounts deposited. Where the petitioner, any petitioner is expired in the meanwhile, his legal representatives are accordingly permitted to do so. Stop the excise commissioner will, after hearing the petitioners, pass a reasoned order thereon within a period of 3 months and communicate to the petitioners the order within a week thereafter. Till such time, no, there's no interim order. You say the court clarifies it is not expressed in view on the merits of the claims of the petitioners. Full stop. If agreed with the orders of the excise commissioner, it will be open to the petitioners to seek appropriate remedies in accordance with the petitions are disposed of.
Well, last item will also may say that.
No, I've said that.
Legal heirs.
Yes.
Weekly running list. Item number 26.
Item 26, my lord, on behalf of Mr. Jana, case becomes infructuous, my lord.
All right. Constable, disposed of his having. All right.
But 15 were the opposite party.
All right.
Item number 27.
Millers, I have been intimated by the legal heirs that the sole petitioner's dad, your lordship, may grant me 14 days time to bring them on record.
What's the matter about, sir?
Matter is on 13.4. They have,
Then you.
but unless they are brought on record,
No, we'll permit the LRs. You see, it is stated that the petitioner has expired during the pendency of the petition. We'll stop permitting the legal representative of the petitioners to approach the debt recovery tribunal in the pending proceedings in accordance with law.
already to the legal yes, your lordship.
That's it. The petition is disposed of. The interim order is vacated.
My lord, already an OA is pending.
That's it. If the pending OA, they
can, my lord, OA 353 or 50.
Your lordship may say legal yes.
Pending proceedings in the DRT.
Your lordship may say legal yes, because petitioner is not legal yes up to.
Yes, they've said legal representatives.
Lords.
Right.
Obligement.
Item number 28.
None appears dismissed.
Item number 29.
No instruction.
No instructions dismissed. Okay.
Item number 30.
I am from the opposite party. My instruction is that the loan account has already been closed.
Counsel appearing for the opposite party informs the court that the loan account has already been closed, disposed of as having come instructions.
Item 31.
None appears dismissed.
We approve the opposite party, my lord.
All right.
Item number 32.
None appears dismissed.
Item number 33.
Same order.
Item number 34.
Same order.
Item number 35.
Wait, please, your lordship. My lord, item 35, your lordship.
Yes.
It is a claim of the subsidy of the petitioner, my lord, which could not be processed by the opposite parties because of the delay caused by the bank in forwarding it. The petitioner has absolutely no role in it. It has come up with a counter, your lordship. The copy of the counter they have not given to me. Since last 7 days, I am searching them and trying to get the counter, but unfortunately, your lordship, I could not get.
Lord, I am appearing for the opposite part number 4, my lord. I am in BC, my lord.
All right, but one.
My lord, your lordship may have a glance to Annexure 8, my lord. Annexure 8 is the our letter by the opposite part number 4. Lord, we have intimated the petitioner that the recommendation has not come in time and it was belated.
Yes, your lordship. My lord, I am submitting, your lordship.
Your lordship may kindly have a glance to Annexure, and that picture will be clear.
My lord, I'm briefing
not processing. We have nothing to do.
Yes, your lordship. My learned senior is absolutely correct, your lordship. But for that reason, I am not responsible. Your lordship may kindly see.
No, but why should he be made a party is the question.
Because he is the sanctioning authority. So he is a necessary party. Your lordship may kindly see. I'm submitting it within 2 minutes, my lord. The petitioner is running a food processing
unit. Who's appearing for 1, 2, and 3? Are you appearing?
Yes, your lordship. That counter is required.
No. Who's appearing for 1, 2, and 3?
I am with petitioner.
I see.
To receive the counter. My associate is there to receive the counter.
No, but who's appearing for them?
They have filed a counter, your lordship. It has come with an
Who's appearing, sir?
My lord. That is Manoj Kumar Mishra, but not my learned senior. I have checked it from his office. Not my learned senior, Mr. Manoj Kumar Mishra. He is not there.
Then you better get a soft copy, sir, from the court.
Yes, your lordship. I will get.
It will be open to the petitioner to collect a soft copy of the paper book.
Sir, I will be given a copy of that counter also.
You also collect a soft copy, sir.
Yes.
Now get used to all this paperlessness.
Yes.
All right. It will be open to the counsel for the parties to collect a soft copy of the paper book from the court master on production of a pen drive.
My lord.
List on. Tenth August.
Obliged.
Item number 36.
Regular.
Item 36.
None appears dismissed.
Item number 37.
None appears dismissed.
Appearing for private OP number 5 in 37.
All right.
Item 38.
Same order.
Item number 39.
Madam, I am appearing for the opposite party workman.
All right.
He in the meantime expired, so his last legal representative may be substituted.
What was the relief granted with the labor court? Let's see that.
Yes, my lord. That order is at
Level
Annex
that
6, my
granted
lord.
relief in 9 hours.
My lord, the dispute here is whether the retrenchment compensation under 25N, the corporation has granted them till 2007. The labor code held that they are entitled to 2010, up to 2010. So, my lord, here 2007, 25N permission was obtained from the appropriate government, from the labor commissioner. 2007, that permission was obtained. But because of the stay order of this honorable court is not to take any coercive action, so that could not be given effect to. It was ultimately when that writ petition where the stay order was granted, that was dismissed in 2010, they were retrenched. So the corporation granted them compensation till 2007, and since payment was made in 2010, the interest from 2007 to 10, that was also paid. So their claim.
What will the actual amount work out? Is only one person, no?
Only one person.
Nothing. Since the amount
that may be
involving the sole respondent workman as regards the compensation payable for a period of 3 years between 2007 and 2010 is not substantial. The court is not inclined to interfere. Moreover, the sole respondent has expired during the pendency of the present writ petition. You allow this. I taken on board. First, you allow this.
In fact, in that
for all of the aforementioned reasons, leaving the questions arising from the impugned award of the Labour Court open for decision some other appropriate case, the petition is disposed of. What about the second one is by the workman?
That was by the workman. That there the workman is claiming that I am entitled, had I continued in that service till the date of my superannuation, I am entitled.
All right. You say for the reasons that today by a separate order, petition civil 9710 of 2015 has been dismissed. The present writ petition is also dismissed. Right.
Obliged.
Item number 40.
My lord, item 40 infructuous, my lord.
Okay. Dismissed as infructuous.
Item 41.
41, I am for the petitioner. In the meantime, the impugned order lost its force. But despite that, my lord, some unauthorized persons are collecting money. This matter relates to Shikhar Chandi temple. An unauthorized association is in form and they are collecting.
That's a separate cause of action, sir.
Your lordship may indicate and approach the commissioner.
All right. Counsel for the petitioner states that the interim order challenge has already worked itself out. As regards any further cause of action, it will be open to the petitioner to approach the Commission of Endowments in accordance with law.
Yes.
The petition is disposed of.
Item number 42.
42, the counter has been filed, but copy has not been served to me.
What's the matter about?
It's a form driver, my lord. Covered by your lordship's judgment. Your lordship can have a glance to para 7, my lord. Page 7, my lord. And also, my lord, similar matter as in the session of court number 1, my lord. They have made queries to the government, my lord. Batch of matters are there, my lord. The lordship, page 7, my lord. I have quoted the order, my lord. And also, your lordship's another judgment is covered by this. The lordship has turned to page 7, Lord.
But you are a panchayat head.
Yes, all they are working as a palm driver, Lord.
No, but your appointing authority is
Sarpanch.
Sarpanch.
But the drawing and disbursing authority is, Lord, the BDO, Lord.
No.
All because the funds, that is why, Lord, whatever they have filed the counter, Lord, let me serve the copy. And Lord, your lordship's kindly have another order, Lord, that batch of matter has been in the court number 1 is sessions of hearing and the case is posted tomorrow, Lord.
All right. Since the issues involved are similar, list this along with writ petition civil 20526 of 2014 before the bench of Justice S. Talabatra and Justice Sakri. Tomorrow, is it?
No, tomorrow, Lord.
When is this coming up?
Yes.
20526.
All the batch matters have been listed in court number 1 tomorrow, Lord.
Court number?
Court number 1, my lord.
Tomorrow, right?
Yes, my lord.
Not court 1, sir. This is Talapatara's court.
Yes, my lord.
That's not court 1. Tomorrow.
Item 43.
42 and 3 is same. 43 and 44 my lord, same.
Same.
43 and 4 also same.
Item number 45.
My lord, item number 45, here, a lease was granted to the predecessor in interest of the present petitioners. The lease is for a period of 90 years. There is no dispute on that. Permission was granted for construction of nursing home. Thereafter, a third party filed a suit against me and got an order of status quo. When show cause notice was issued, I filed my show cause, but they don't deal my show cause properly and reject my for the lease. They revoke the lease. Till that, government has not filed any counter. Now, in fact, my lord, the suit has ended and I have taken position. Substantial construction is there. If they can verify also, they can see, because I have not misutilized the land for any other purpose. It is for construction of nursing home only. There is no allegation only allegation that you could not complete. I filed my show cause that there is a civil suit filed by a third party, status quo order is there, and unless the status quo order is vacated, I cannot complete the construction.
I'll take instructions regarding this. No, we'll send it back to you. I think that's best. He said a challenge in the present petition is to an order dated 1st July 2015, passed by the General Administration Department, Director of Estates, General Administration Department, Government of Orissa, cancelling the lease granted in respect of what plot is it called?
My lord, it is leasehold plot. Your lordship.
Something. Determination of lease in respect of some drawing plot.
Yes, my lord.
Drawing plot number A/112.
Page 11, man.
No. 1187 again. It's Nagar Unit 3, Bhubaneswar. Leased out in favor of the predecessor in interest of the present petitioners, on the ground that he had failed to construct the nursing home for the purposes of which it was granted. Paragraph. According to counsel for the petitioner, the above order was preceded by a show cause notice to which the predecessor in interest of the petitioner replied, pointing out that there was a civil suit filed against him in which there was an interim injunction, as a result of which no construction activity could be carried out. Paragraph. In the present petition, notice was issued way back on 3rd November 2015, and it was directed that status quo would be maintained. That interim order is continued. Paragraph. In the last 7 years, no counter affidavit has been filed by the state government to contradict any of the arguments in the petition. To stop. Mr. Bose, learned counsel, the petitioner informs the court that the aforementioned civil suit has now been dismissed.
Yes.
And the interim injunction granted therein has been vacated. To stop, he adds that the petitioners have also raised a construction to a substantial extent on the plot in question. To stop, he praised that with these developments, the government should be asked to re-examine the entire matter. Paragraph. In that view of the matter, the impugned order dated 1st July 2015 is hereby set aside, and the matter is remanded to the Director of Estates to re-examine the entire issue by hearing the petitioners afresh after considering their further affidavit of facts, which will be filed before him not later than 3rd April 2023. Stop the Director of Estates will give a hearing to the petitioners on a date to be informed to them at least 10 days in advance, and thereafter pass a fresh order on the show cause notice issued within a period of 3 months thereafter, till such time status quo as ordered by this court on November 2015 will continue. The petition is disposed of in the above.
Grateful, Your Lordship.
Item number 46.
None appears dismissed.
Item number 47.
In this case, my lord, the workman was appointed as contingent manual on a daily wage basis. In the year 1992, and was removed since the post was abolished. He was removed from service on 29 to 1994. My lord. He has only worked for 1.5 years, my lord. Thereafter, he raised the dispute before the labor forum, and the government slept over the matter, and government made the reference after 18 years, my lord. The disputes were of the year 94. Government has made the reference in 2013, my lord. After 18 years. And the award is given that he should be reinstated with 50% back wages, my lord. My lord, in the meantime, the ID Act Section 2A has been amended. Section 2A that was amended in 2010, my lord. There they have made a provision if within 45 days government didn't make a reference, the workman can directly approach to the labor court, making a directly file the case, which will be treated as a reference. But even though the amendment came into force on 15/9/2010, but the government made reference in 2013, my lord. That is 19 July 2013. But the workman remains silent. He could have approached the labor court directly as per the section 2A, that is amended provision. Amended provision that is 2A subsection.
For the workman. I'm for the workman, my lord. My response submission, my lord. One miscase 17256/2016 is pending since 2016. And when the grievance of the before the miscase, my lord, they have not paid the 17B.
Oh, that has to be done, sir. First.
17B is getting.
But
He's
not
claiming
as per
higher
the
rate.
direction of the
You file an affidavit. You say 17256 of 2016. The grievance of the workman in the present petition application is that his 17 capital B wages are not being paid as directed by this court by its order dated 14th March 2016. Paragraph counsel appearing for the petitioner management disputes the above averment submission.
He's getting 17B as
and
per the-
states that the management will file petitioner management will file an affidavit in this application.
Yes.
Not later than 1st March 2023. Reply thereto if any be filed with the next date list in the regular manner on 29th March. Sorry, 29th March. 29th.
Item number 48.
Wait, Your Lordship. The petitioner purchased the land from the lessee. The lessee had been granted leave by the government.
7B3.
So lessee, my lord.
No, 7B3 or what? What's the matter about?
OGL. OGL is matter.
So that's covered by that Narottam Ratha.
No, my lord, it is not.
This is the
No, it
against
is-
ADM's order, I think.
No, it is not.
So.
Not so. It is actually what has happened. The authority has passed an order without giving us opportunity. They say that we have not filed any documents. But the thing is that there is no notice, nothing of the sort. As a result, we have no scope to know about it. Only
Can
my
I-
limited prayer
can I
is that
get the file?
let the authorities, I will produce all the relevant documents. We'll file all the relevant documents and authority may take a fresh decision because that is also, the government has not filed any counter. That is also my specific plea in the writ petition, para 10. The order the Lordship kindly see. Page 7. Page 7, my lord. Page 7.
Yes, I've seen
Petitioner
this.
has not filed all the relevant documents in support of the claim. Hence, this case is disallowed for want of necessary documents. That is the madam. It is actually, we had no scope to, because we are in
This says
function of-
notice properly served, petitioner is present on call and filed what? Something.
No. In the previous date, my lord, not
Filed Hazira.
filed
Just see page
Hazira.
7.
Petitioner filed Hazira, has not filed Hazira.
That is,
My lord, dear
No, no,
also
no.
kindly see record is presented today, notice properly served, petitioner is present on court, and this and files Hazira, that is the previous, my lord, Apathikari Tarapuru, but you'll also kindly see the ground of decision. The petitioner has not filed
No,
all
that's
the
true. You started off saying you never had proper notice. You never.
Yes, my lord, that is because you filed Hazira, I don't. That is one. Actually, if you also will give me an opportunity to, because this is a regular lease deed, the petitioner vendor had got the lease deed, and also we have got this registered sale deed. So only these things are to respond to the authorities.
You had applied for mutation, is it?
No, not for mutation, my lord. It is for when the settlement proceeding, my lord, this thing happened, my lord. Because we had the parcha had been issued in my name, Annex 3, my lord.
No. When it says disallowing the case, whose case is this?
It is for to record. It is now recorded in the name of the government. So then, because the
so you wanted your name to be entered.
Yes, my lord.
The ROR.
Yes, my lord. That's right.
My lord, the order, impugned order indicates that he was very much present. He filed.
So he's now saying it was because he did not file documents, and he says he has documents. Okay.
Documents. What document he has filed in this case? Nothing.
He not that out of.
He has not even filed any documents to show that he has got any indivisible title over the property in question.
No. He has filed sale deed.
Only that sale deed is.
It has been
Registered sale deed,
reported.
sir.
Lease deed has also been
It's a
reported.
registered sale. That itself is an important document. If the challenge in the present petition is to an order dated 28 December 2012, passed by the Assistant Settlement Officer of the Tahsildar,
Yes, ma'am.
Bhubaneswar.
Settlement. Assistant settlement officer.
In what's the case number?
My lord, so far as the sale is concerned, the annexure 7 reveals that he has considered it. I am just placing the petitioner has purchased an area of 1 acre from the said plot and claims to record in her favor, verified the documents, and everything he has filed before the concerned authority.
Which page?
Apurva ko case
15320.
15320.
There are only 5 annexures.
Yes, here he has not filed the documents in one file, but in other case he has filed all the documents.
Make a submission.
No. So this you say counsel the petitioner, senior counsel petitioner states that the impugned order dated (28/12/2012) was passed by the Assistant Settlement Officer, declaring the prayer of the petitioner to enter his name in the record of rights in respect of the plots 564 by 777, Khata number 229 of 20, over an area of AC 0.150 decimals. In his favor, in his name. Post of paragraph, counsel for the petitioner, senior counsel for the petitioner submits that the petitioner purchased the above lot under a registered sale deed dated 1st February 2005 from the original lessee. Full stop. However, as noted in the impugned order, the petitioner could not produce the documents in his possession, resulting in the impugned order rejecting his plea. Paragraph, despite notice in the present petition being issued way back on 5th February 2016, till date, no reply has been filed by the opposite parties. Stop. Paragraph, the impugned order is a cryptic one, noting just one reason, namely that the petitioner was unable to produce documents in support of his claim. Paragraph, court is of the view that the petitioner ought to have been given one chance to produce the relevant documents. So that view of the matter, impugned order set aside, and the matter is remanded to the Tahsildar now. No? Mr. Monti?
Yes, my lord. ASO is now Tahsildar.
Tahsildar, what? Which place?
Bhubaneswar, I think, or Jatani. Which Mauji?
Bhubaneswar, Shahid Nagar. Tahsildar Bhubaneswar, where the matter will be listed. What's the case number, sir?
My lord, the case number is stated in the top 4100.
Objection case number 4100/589 of 2012. Of Mauja Bhuasuni.
Objection case number 510
4100. Objection case number. Objection case number.
589 of
2012.
Will it be listed for directions on 3rd April 2023, on which date the petitioner through counsel will appear, along with the downloaded copy as well. The Tahsildar is directed to take on records the documents produced by the petitioner on that date, and after hearing the petitioner, to pass appropriate orders in accordance with law within a further period of 2 months thereafter. Stop till such time fresh orders are passed by the Tahsildar. Status quo shall be maintained by the petitioner. By the parties. By the parties. What's about the connected matter, sir?
And next matter, my lord, the case is same, but here the reason has been there. Your lordship kindly see page 7.
Here the order is totally
page 7, your lordship
there is
kindly
a reasoned order. The order
page
is a
7. I'm
reasoned order.
just pressing, my lord. Page 7, my lord. The case is here is another petitioner. He has also got the property from sold it from the lessee. Well, the case is taken up today, and the petitioner has claimed this record plot number so and so, and my record is named that the plot number so and so.
This must be an appealable order.
So petitioner has purchased the area of my lord. My lord, what I humbly submit, my lord. Now they say that you have not filed the copy of the lease deed, and they also asked for the Tahsildar. So directed Tahsildar to produce the lease deed. Tahsildar had also not produced. My lord, may I permitted to get another chance to produce the lease deed, because I have purchased from the bona fide purchaser. So if I am permitted to produce the lease deed, then I think because I am bona fide purchaser, that is the reason I cannot be deprived of my law.
Submit all the records before the appellate authority.
Counsel for the petitioner seeks leave to withdraw the present petition with liberty to file an appeal against the impugned order dated 29 December 2012, passed by the Tahsildar.
Yes.
Bhubaneswar, is it? Yeah, Tahsildar Bhubaneswar.
The limitation part may be considered, my lord. They may consider the period.
I see.
The limitation part, my lord, will also kindly consider they have considered the for condemnation of delay. Because
on the ground that the petitioner was unable to produce the relevant lease deed in favor of the vendor of the petitioner. Full stop. Counsel, Mr. Lansina, counsel, the petitioner states that petitioner has in his possession the original of the said lease deed and should be permitted to produce it before the Tahsildar. In the said objection case number 4101/12. Well, or /590 of 2012. Paragraph. Despite notice having been issued in the present petition way back on 6th November 2015, for more than 7 years now, no reply has been filed to contradict any of the amendments the petitioner. Full stop. The impugned order being an appealable one, it is directed that if the petitioner files such appeal not later than 1st March 2023, accompanied by an application for delay, citing the pendency of the present petition as the reason for the delay, will be considered in accordance with law by the appellate authority. The court clarifies it is not expressed any view in the matter. Paragraph. It will be open to the petitioner to produce before the appellate authority the lease deed in favor of the petitioner's vendor and any other document that the petitioner may have in support of his claim, her claim. The appellate authorities requested, if the appeal is filed within the time indicated, to dispose it off within a further period of 3 months after hearing the petitioner. So till such time, status quo as of today shall be maintained. The petition is approved.
Item number 49.
I am asking for OP number 2, workman. Till now they have not complied the 17B of the idea.
Who's for the petitioner, sir? 1 minute. Who's for the petitioner?
This HK Mahanti is now joined as a member consumer. So maybe someone may not be given. Or
let it be come after 2 weeks. And direction will be given to comply the order of this honorable.
There is to be somebody there for them to understand that order and come implement it. If in the absence of somebody, if you simply pass the order, nobody will be there to implement it.
Previously, it was allowed.
Correct. If he pass such an order today, there will be nobody to implement it. There's nobody present today.
Let it come after 2 weeks.
If you dismiss it today, you file your 33C and get it implemented, sir. None appears for the petitioner. Dismiss for non-prosecution. The interim order is vacated.
For opinion number 1, where you resume appearance of the Mr. Gyanalok Mahanti appearing for opinion number.
All right.
Item number 50.
In fact, there's no interim order, I think. Oh, there is. Right. Interim order is vacated.
Item number 50.
None appears for the petition. Dismissed for non-prosecution.
Item 51.
None appears for the petition. Dismissed for non-prosecution.
Item 52.
None appears. Dismissed.
Item number 53.
Password, my lord.
Item 54.
None appears. Dismissed. The contempt case you see with the dismissal today of petition 720897 of 2015. This petition is disposed of with directions to implement the order in petition civil 18227 of 2013 in accordance with law. Oh, even the contempt case is disposed of, then forget it. All right.
Item 55.
See, 55, I am challenging the annexure 5. The demand notice dated 17/10/2015. So the counter already filed by the opposite party, no 2 and 6. Copy but not served.
You can go to the commissioner, no? The demand notice by who?
Demand notice by the opposite party, no 6. With the manager, Baleswar Bhadra Central Cooperative Bank Ltd.
Central Cooperative Bank, okay.
The loan was sanctioned for poultry farm. Out of 13 lakhs, 3 lakhs has been released in favor of the petitioner. Due to local hesitation of local people, he could not function the poultry farm. There the petition filed a representation.
Complied with this 22/12/2015 order?
Yes, my lord. 65,000 already I have deposited.
Who's for the other side? Who's for the bank?
Of which technology is a separate council.
Let it remain on board. You have to find out who for the opposite parties.
The counter copy also not served to me.
That's what you can take that from the court master. You take a soft copy. The content now disposed of.
Item 56.
Lordship, urgent this matter.
Stay on board, sir.
Mr. Baidhara Sahu, you contact Mr. Baidhara Sahu because he has identified in the affidavit while filing the account.
Item number 56.
None of these dismissed.
Item number 57.
57, my lord. I have requested my senior. I have some personal that I'm not feeling well. Let it come 2 weeks after.
Not 2 weeks, sir. Tomorrow.
The status quo order is there. Status quo order is there. My lord, we want to acquire the land by bilateral discussion. That is as per the government guideline. Annex D we have given. And my lord, thereafter we have notified those who have any objection or anything. You would give that. Otherwise, you will give the requisition to the collector for acquisition of the land for industrial infrastructure development. But because of the status quo order, everything is stalled. Because this is a seafood park, road is to go there to the industrial estate near Deras Chandka area.
Let it come 2 weeks after. I'm not feeling well. I have not gone to the
Feeling well, not 2 weeks, sir. Should get well sooner.
After 30th any day.
How do you know 13th you will suddenly start feeling well? How do you know 13th suddenly you will start feeling well?
I leave it to my lord.
I want you to feel well tomorrow itself, sir.
Tomorrow?
Feel well. We'll take it tomorrow. Tomorrow, let us see what happens.
1 week after.
Tomorrow we'll see what happens. We'll see how you're smiling already now, sir.
I may pardon next week.
We'll see tomorrow. We'll see.
I may pardon next week any day. Next week any day.
It's all right. It's all right.
Next week any day.
It's okay. Yes. Stay on board. Yes.
Item number 58.
I may pardon
Only if you come, it will continue.
And I will pardon next week.
All right.
Item number 58.
We'll take up this tomorrow. We'll take.
Next week is on board.
It's on board. It will get called out tomorrow.
Madam, next week.
Let us all hope he feels better tomorrow.
Madam, next week. Madam, next week.
No. All right.
Item number 58, my lords. I am there on the virtual mode, my lords.
Yes. Tell me.
My lord, this it is an industrial dispute matter, my lords. Your
Yes.
lord, this honorable court granted, issued notice of admission on 16 to
2016. Correct.
16. My lord,
Not served on him, sir. He's not to be found. The workman is not. He's absent.
But interestingly, he has filed a 33C2 application before the London Labour Court, basing on the award. And my lords, after submission of the stay order granted by this honorable court, the 33C2 proceeding has been stayed. And he is aware of the fact, but notice has not been made sufficient as it is revealed now, my lords. Earlier, AD not back, so this honorable court said, awaiting with AD, let it post for 2 weeks after. But thereafter, my lords, it has not been listed. And it's a peculiar award. Your lordship find that the date of termination is 22/3/2010, my lords. My lord, 22nd March 2010 is the date of dismissal, and his date of superannuation is 30th of April 2010, my lords. Only 1 month, my lords. If at all the termination is held to be bad, my lords, he will be entitled for 1 month salary, my lords. But we had conducted some inquiry and some amount are due from him. And we adjusted his retail benefits, all those things from that amount. And my lords, only 1,32,000 he is to pay now. Now the court has said.
So if the award goes, he will not pay you. It's only because of the award you have calculated that he needs to pay you.
No. Before that.
So if you allow your petition, set aside the award, he has to pay you nothing.
Yes. That you
so we can happily do that so that we save him from paying you 1,32,000.
No problem. Yes, ma'am.
So we set aside the award, and so we'll make it clear that he should pay you nothing.
No, nothing will not. Your Lordship has set aside the award. That is my prayer in the writ
No,
application.
you say because of the award he has to. You have now calculated and found because of the award he has to pay you 1,32,000.
No, not an award.
That's what you said. You just now said that.
I didn't say that. I said that the management has conducted inquiry and
you conducted that inquiry only because of the award, sir.
No. Award is later on. Award is later on, my lords. Award is later on. Your Lordship may kindly see the in that case, your Lordship may kindly see. Three paragraphs is important, my lords. Paragraph 11, 12, and 13 of the award is paragraph 11 is page 21, my lords.
What is the amount given to him under the award?
Particularly, he has said that he is entitled to compensation. Your Lordship may kindly see the last portion.
So even if you pay him 10 paise, you would have satisfied the award.
No. I'm not on that, my lords. Your Lordship.
No, we are on that, sir. See, all this entire exercise of two High Court judges sitting, listening to learned arguments of Mr. Mishra and passing judgment should result in something.
My lord, my prayer is the award is unintelligible.
Yes.
And it's a nothing has been said. No compensation. I mean, he has not.
Then what is your grievance? What is your grievance? If nothing has been given to him in the award, what is your grievance?
The award has to be set aside.
What? Giving him nothing. So for giving him nothing, we have to set it aside.
No, I have nothing to say. I have nothing to say.
You better make up your mind. If we set it aside, we'll say Mr. Mishra is very aggrieved that the award gives the workman nothing. The only inference is Mr. Mishra wants the award to give him something.
No.
Yes. If you're unhappy that the award gives him nothing and we agree with you, then we have to give him something. You better make up your mind what you want. Award gives him nothing, correct?
Yes.
Yes. So we set aside the award, then we have to give him something.
So in that case, your Lordship may say I did not press. Because he has
very good. So finally the result is achieved.
No. He has approved the 33C2 court basing on
it's all right, sir. It's all right. See, these workmen have no litigating capacity. They can't take on powerful parties, powerful counsel like Mr. Mishra.
No, my lord, it's not that. Yes. My lord, he has approved the 33C.
See, for him getting nothing itself, we have challenged the award. Imagine if he had got something.
I leave it to your Lordship then. I want to get better justice than your Lordship.
All right. Mr. Mishra agrees that the award gives nothing to the workman as compensation. In that view of the matter, he does not wish to press this petition. It is dismissed as not pressed. All right.
Item 59.
Yes. In a small date set, you'll see.
Yes.
Annexure 1 and page number 15, Annexure 2. A industrial dispute has been raised by the union regarding termination of the contractor employees. Accordingly, a failure report was submitted by the conciliation officer. You'll also have a prior to the impugned reference, you'll also have a glance at the section 12(5) of the Industrial Dispute Act. What is the extent?
Whom are you appearing for, sir?
I am appearing with OP number 5, my lord.
Who's for OP number 3?
Is the contractor, you'll see.
Who's for him?
Nobody is acting.
No. I think service to him is not complete.
My lord.
AD not back.
You'll see.
There's no stay also.
There is 2 errors. Well, let's a glance to order dated 11th of January 2017.
Oh,
matters in state.
All right. Fresh notice be issued to opposite party number 3. Put in the regular list. Returnable on.
Interim order to continue. Let's
12 July, interim order to continue.
Oblige.
Obligement. Item number 60.
None of this.
Item number 61.
May I please, Your Lordship? Well, I have prepared a small date. One leave has been granted in 574 to one Abhimaji, my lord. After 23 years in 1997, the opposite party member has invoking his power under section 7A of the OJLS had cancelled that lease.
Where did you buy it?
Thereafter, the
when did you buy the property?
11th May 2007.
Thereafter, the lessee has.
When did you buy the property, sir?
Sir, in Bhubaneswar, madam.
No, when?
When, sir?
When? Well, the lease was granted in the 74.
Cancel hela pore kinichanti na purboru kinichanti.
Na cancel hela pore.
After the
after cancellation, he has approached the lessee has approached this honorable court by filing a writ petition bearing number 11,089 of 1997. This honorable court, after setting aside that order, remanded the matter to opposite party number 2 for fresh disposal after giving due opportunity. And the opposite party number 2, after by law pursuant to that order, after giving a due opportunity, will come to a conclusion by the annexure 1, and that the lease was granted validly in favor of that Abhimaji. Thereafter, my lord, thereafter he has after getting permission from the competent authority, sold that land to one Baliar Singh, and Baliar Singh sold that land to one Rupnarayan Agrawal, and proper Rupnarayan, these petitioners purchased 2 subplots, that is subplot number 9 and 10 from that Rupnarayan. Thereafter, my lord, in 2013, when the Khanapur stage was there by the settlement of the authority, my lord, they again recorded that land in the name of a government. Challenging that order, he has filed an appeal. Your lordship, kindly see Annexure 8.
Narottam Ratan. This is ASO's order.
ASO's order.
Not covered by Narottam Ratan. You're not aware of that order?
Both. Reference is WPC number 1.
Now all the fees will go to that man. You won't get any fees. He will only get.
Right. Both the matters
order passed to this court in Narottam Ratan.
Both the matters are same, my lord.
Right.
Item was 61 and 62 same.
All right.
Item number 63.
This is John lease.
Gone.
That is
over.
Gone means
you now get only compensation under the new policy.
That your lordship may do that, but lastly, this honorable court had directed.
Now, Jawan lease and all you can frame and put in your house. That's all.
He will be entitled for 50,000 provided he is eligible.
Correct.
Now, that has been considered by the Tahsildar. Tahsildar says land is not there.
That's what.
That is they are saying.
Under the extant policy, where the system of awarding Jawan leases is no longer prevalent. The only relief that can be granted to the petitioner is to apply to the government in terms of the current policy for compensation in accordance with law. If such application is made not later than 1st March 2023, the government will communicate its decision thereon to the petitioner within a period of 3 months thereafter. The petition is disposed of. All right.
Item number 64.
None appears dismissed.
No, I'm there.
Oh, you're there.
All right. Here's the State Department land. I was allotted the land. I filed the lease deed in 1992-93. They demanded 70,000. I paid that. But for some reason, they didn't execute the lease deed by Annexure 2. Now, thereafter, I made a spate of representations. Annexure 7, your lordship will see, they demanded the representation. I don't take your lordship through.
Where is the land, sir? Bhubaneswar?
Yes, my lord.
What's the worth of this land now?
Now it is.
Now at Annexure 11 is improved.
No. What is the worth of this land?
That is what they have demanded.
No. Today's market value.
Today's market value.
That's the same.
What's the market value of this land today?
But I paid the entire thing. I'll pay with interest. This amount, I'll pay with interest.
He's become clever now. You best withdraw the writ petition.
But I have no writ fault. Because
Others you'll be in trouble. We'll ask you to deposit market value now. You'll be in trouble.
withdraw, my representation to be considered.
No, you withdraw. You're not going to get it at this rate at all.
In fact,
This is all Bhubaneswar land.
No? In fact, I'm not at fault. I made the deposit in 1992.
All right.
Entire lease deed money are paid.
All right.
All others have been, they've got at 55, 1 lakh, 12 lakhs. But as far as I'm concerned,
these kind of matters you should pay under protest at least. You're missing an opportunity. Anyway, counsel the petitioner does not wish to press the present petition with liberty to approach the government for appropriate relief in accordance with law. This post of is withdrawn with liberty is great.
May I pray, my lords? I mean, pardon, my lords. Item number 58. Item number 58, your lordship just now heard, my lords. Item 58, that industrial dispute matter. My lord, why I filed, your lordship asked me, he has not awarded anything. Why you filed the writ application? So there, my lord, the London Labour Court has said that the inquiry which was held by the management for realizing some amount from the workmen, my lord, that was bad. On the ground.
It's okay, sir. You don't drag him, he will not drag you to the court. Best. Live in peace. Live in peace.
He has already dragged to the Labour Court, my lord.
Anyway, you've dragged us. We have already given our order. All right.
Item number 65.
65, no instructions, man.
No instructions.
Petitioner is no more. I'm filing a memo, man.
All right. Both matters.
Only, yes, man.
Both matters.
Item number 66.
Now I'm going to plead 448.
Before me, I saw everyone has been compensated. Now,
you already got so many orders today.
I have not got. I have not got compensation.
Tomorrow. We'll take it up tomorrow. First item.
Much obliged.
All right. Thank you.
Much obliged.